Thank you, and congratulations, everyone, on making it to the high school mock trial state championship. I am the Honorable Judge Nicholas Monk. I will be your presiding judge today. I will get this started by asking each side if you are ready to go to trial.
The people are ready, Your Honor.
Thank you. Defense?
The defense is ready, Your Honor.
Thank you. The judges have already been provided with a copy of the trial rosters with the team code. As you are probably likely aware, this is being video recorded and being posted and streamed online. Gallery members are not present, so will not be able to participate in any way, but a reminder that you are not to communicate with any individuals outside of this round. No recesses will be allowed with the exception for health emergencies. Specifically, no recesses will occur between the end of witness examinations and the beginning of closing arguments. We have already done a conflicts check, but do any of the team members wish to argue that any of the panelists that you have seen is biased in any way? Hearing none, I will remind teams that any disputes arising out of the competition must be recorded in accordance with the competition rules. Teams, your compliance with time requirements will be considered with when scoring individual performances. No one's in the jury box because we don't have one. Can I quickly have everyone, all of the participating team members, just come on camera, come on mic, say something as a tech check, and please introduce yourselves at the same time. Thank you. Let's start with the people.
Good morning, Your Honor, counsel, members of the jury. My name is Feliciana Sayers, and today I represent the people of the state of Colorado. Permission for Mr. Powell and Ms. Proctor to introduce themselves.
Yes, please.
Your Honor, counsel, and members of the jury, my name is Chalmers Powell, and I represent the people of the state of Colorado.
Good morning, Your Honor, counsel, members of the jury. My name is Madeline Proctor, and today I represent the people of the state of Colorado.
May our witnesses now introduce themselves?
Yes, that would be appropriate.
Good afternoon, Your Honor, counsel, members of the jury. My name is Trenton Schultz, and I am Detective Jordan Markowitz.
Good afternoon, Your Honor, counsel, members of the jury. My name is Benjamin Phillips, and I am Kyle Kuzak.
Good afternoon, Your Honor, counsel, members of the jury. My name is Juliette Brunner, and I am Alex Cifuentes.
Thank you. Do the people have any additional individuals that they want to introduce at this time?
No, Your Honor, that is all for the people.
Thank you. Now turning over to the defense, please introduce yourselves, come on camera as well as on mic.
Good morning, Your Honor, counsel, members of the jury. My name is Max Seitel, and today I will be presenting the opening statement as well as conducting the cross-examination of Kyle Kuzak and the direct examination of Blake Van Allen.
Your Honor, before we continue, I would like to bring to attention the fact that one of our competitors is still having technical difficulties. If we could allow one more moment before we proceed, so that he may get on to the meeting.
Duly noted. For the sake of time, can we insert him at the end of introductions? I understand that that might mean that an attorney is introducing themselves following a witness, but if you have a prepared order, let's just move on to the next one, and hopefully the final team member has joined us at the end of introductions.
Yes, Your Honor. Good morning, Your Honor. My name is Marcus Winton, and I will be conducting the the cross-examination of Detective Jordan Markowitz and the direct examination of Miss Avery Becker, as well as the closing argument. May our witnesses now introduce themselves?
Yes, please.
Good afternoon, Your Honor. My name is Brandy Mallender, and I'm Taylor Perkins.
Good afternoon. My name is Paige Funchy, and I am Blake Van Allen.
Good afternoon. My name is MJ Mintz, and I am Avery Becker.
And has that final contestant from the defense team joined us yet?
He is still having technical difficulties, Your Honor. If we could request a little more time.
I'll defer to the courtroom monitor on how to proceed. I am willing to give a few more moments, but do want to keep as closely to the schedule as possible today.
Yes, Your Honor.
When is the attorney scheduled to present? The missing attorney, what is their role today?
Your Honor, the missing attorney, he conducts the cross-examination of Alex Cifuentes first, so it would depend on the people's witness order.
Your Honor, the Alex Cifuentes is last in our witness order, I believe, so that should be okay.
Thank you. I appreciate that. Then everything that's been told to me with the courtroom monitor's sort of approval, I am willing to begin the trial with the understanding that the final attorney will join us partway through, and hopefully, best case, the mic and video is all working at that time. Is that okay with the courtroom monitor?
Let's go ahead and proceed. I will double check this with my coordinator. If there are any issues, I will interrupt.
Fantastic. I'll quickly check with everyone in the room. I was able to hear everyone loud and clear. I was able to see everybody just fine, but speak up now in case any of the presiding judges or other contestants had any issues, were not able to hear people. Now is your moment to make that clear. Hearing nothing, I will now move on to the swearing in, beginning with the team members, the contestants. Team members, if you would all please raise your right hands. Team members, do you promise that the presentation that you are about to give will faithfully and truthfully conform to the facts and the rules of the mock trial competition?
I do.
Yes, Your Honor.
You can lower your hands. Witnesses, please raise your right hands. Witnesses, do you promise that the testimony you are about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition?
I do.
I do.
Yes.
We have no gallery members, so I will be skipping that oath. Finally, scoring panelists, please raise your right hands. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
I do.
Excellent. Give me just one moment to get my computer screen now set up. All right, before we go on the record, I just want to make sure that both teams have designated timekeepers and that somebody will be keeping track of time.
The people have a timekeeper, Your Honor.
Thank you. Defense, do you also have a designated timekeeper?
Yes, Your Honor.
Okay. We will now go on the record. Once again, this is the Honorable Judge Nicholas Monk presiding. To begin with, do the people have any preliminary matters that they wish to address before me before giving their opening statements?
Yes, Your Honor. The people have 3 preliminary matters. For our first preliminary matter, the people request that the stipulated facts be constructively read into the record.
Stipulated facts have been constructively read into the record.
For our second preliminary matter, the people request that the jury instructions be constructively read into the record prior to closing arguments.
Does the defense have any response or any opinions on when the jury instructions shall be constructively read into the record?
There are no objections to that. We agree.
Okay. That's fine. That's how it'll go.
Finally, Your Honor, as the court is keenly aware, COVID-19 has brought on new challenges for the courts, especially in the presentation of evidence. The people are pleased to announce a plan for the virtual presentation of exhibits. We request that while entering an exhibit, we ask the witness and counsel to refer to their case material, and if it is admitted, we ask that it be screen shared to the jury.
I'll turn again to the defense. Do you agree to do that, or do you have a different way that you would like the evidence to be presented and referred to?
The defense would like to clarify that pursuant to Rule of Competition 7.4, for the purposes of our online competition, exhibits that are displayed on screen will not be shown to the jury unless we specifically request to publish, but exhibits may be shared on screen for purposes of identification prior to admission.
Do the people have any additional thoughts based upon what the defense has just said?
Your Honor, Rule 7.4 allows for the witness to refer to their case material once asked by an examining attorney. But we are willing to allow them to share evidence whichever way you would like, Your Honor.
I am absolutely okay with how you described it, though for sake of practice, as well as making things abundantly clear, I would like you to affirmatively make it clear when you want the evidence to be displayed constructively to the jury. So just because it's displayed on the screen, don't assume that the jury has seen it or is seeing it. My preference would be you include some additional, line or question to, now please present to the jury, something along those lines, just to be clear, and allow the opportunity to object at that time as well.
Yes, Your Honor.
Yes, Your Honor.
Anything further from the people?
No, Your Honor. With that, the people are ready to proceed.
Great. Any preliminary matters from the defense?
Yes, Your Honor. First, we'd like to request that all privileges previously extended to the prosecution also be extended to the defense.
Yes, of course.
The defense would also like to request that even though we've all made the best efforts to be in a setting of the best internet capabilities, if at any time you cannot hear or see us, please let us know.
Yes, of course.
And Your Honor, for the record, all witnesses will be present for trial today and may not be sequestered pursuant to Rule of Competition 5.3.1.
I noted that rule of competition. I will once again turn to the people just to make sure that that is also their understanding, that there will be no constructive sequestration of any witnesses during this trial.
Yes, Your Honor.
Okay. And all witnesses will be both physically present as well as in reality present in the courtroom, and will be allowed to reference other witness testimony during today's trial. Is there anything additional from the defense?
No, Your Honor, the defense is ready to proceed.
I will move back to the people to begin their opening statement.
Yes, Your Honor. Towers, texts, and tantrums. Mackenzie Brackman was an attorney. Running around all day was just part of the gig. He also volunteered his time at the local high school as a mock trial coach. So for him, moments of rest were few and far between. On March 6th, 2020, though, he finally got one of those moments. No more waiting for his upcoming trial. No more worrying about the reports of the coronavirus coming to the States. No. Today was his day to focus on himself. Ding, motion at your front door. Ding, motion at the side gate. And as the back door slides open, one more alert. It all happened so quickly, and Coach Brackman reached for a defensive weapon. One moment he was relaxing, and the next he was fighting for his life. But before he knew it, there was a knife in his back, and he was bleeding out on the floor. The masked and hooded intruder fleeing the scene. Turns out that intruder was Avery Becker. Your Honor, counsel, members of the jury, my name is Madeline Proctor, and together with Feliciana Sayers and Chalmers Powell, we represent the people of the state of Colorado. Now, we have the burden in today's case to prove beyond a reasonable doubt that the defendant, Miss Becker, committed the crimes of second-degree burglary, which is criminal mischief, and by extension, first-degree murder. We will meet that burden. For now, focus on 3 things: towers, texts, and tantrums. Towers. Detective Markowitz used cell tower data to find out where Avery Becker was on March 6th. Those records prove that she was at the house of the defendant during the time of the break-in, of the victim, during the time of the break-in and the murder. Her phone pinged not once, not twice, but 3 times in the same cell tower arc as the victim's home. Texts. Alex Cifuentes received text messages from the defendant's phone threatening to vandalize Coach Brackman's house. These messages were sent the day before the murder. They paint a portrait of the defendant's motive to go to Coach Brackman's house on March 6th, break in, and vandalize it. The messages prove her intent to vandalize his home, and the resulting crime scene proves she followed through with it. Tantrums. Avery Becker went to Coach Brackman's house on March 6th to vandalize it. It was a burglary gone wrong. You see, Miss Becker had won some awards at the regional mock trial tournament, but Coach Brackman told her she did not deserve those awards. So what did she do? She got mad, and she took a permanent marker to Coach Brackman's car. When he saw this and kicked her off the team for good, she got even madder. This gave Miss Becker all the motive in the world to go to Coach Brackman's house, break in, and vandalize it. The defense has no obligation to present evidence in today's trial, but we expect that they will. Their purported expert has only ever testified for the defense. Taylor Perkins is loyal to the defendant, and he has proven in the past that he will go to extreme measures to help his friend. And the defendant has every possible reason not to tell the truth. Towers, texts, and tantrums. Members of the jury, the case before you today is a tragedy. Coach Brackman dedicated his life to helping shape the future leaders of America. He was a shining star in the community, but that light extinguished when he bled out on the floor of his entryway on March 6th. Towers, texts, and tantrums. At the end of today's trial, Mr. Powell will stand before you and walk with you through the evidence. He will ask for a verdict of guilty. Thank you.
Does the defense wish to make an opening statement at this time?
Yes, Your Honor. Before I proceed, can you hear and see me clearly?
Yes, I can.
If any time that changes, please feel free to interrupt me.
Absolutely. Whenever you're ready.
May it please the court?
You may proceed.
You can't see the big picture when half the pieces are missing. Today, the prosecution is presenting a half-finished puzzle, and they are asking you, the jury, to overlook all of the missing pieces. And because of this, a young woman's future is at stake, and a killer may get away. We can't change the past and bring the victim back to life, but we can bring justice to this case today. On March 6th, 2020, mock trial coach Mackenzie Brackman was found dead in his home. He had been stabbed and murdered. We agree with the prosecution about that irrefutable fact, but that is only a half-finished puzzle. The prosecution will try to fill in that puzzle. They'll try. But all they have is incoherent and faulty evidence that came from a rushed investigation. But you will hear the truth. You will hear from Taylor Perkins, a close friend of Avery Becker, that the day before the murder, They were at the local fry shack playing games on their phones. Taylor Perkins will tell you that Alex Cifuentes, a fellow mock trial teammate, could have stolen Avery Becker's phone. That the next day, when Avery Becker realized she was missing her phone, Avery Becker and Taylor Perkins spent the entire day of March 6th looking for the phone, not breaking in to someone's house. Next, you will hear from private investigator Blake Van Owen. She will pick apart the prosecution's half-finished puzzle by going through the specifics of the crime scene, including the stabbing and break-in. She will prove that the prosecution's crime scene reconstruction was inaccurate. Furthermore, she will go through in-depth cell tower data that backs up the alibi provided by Avery Becker. All three of these witnesses will discuss Blair Rollins, another suspect in today's case who was barely looked into by the prosecution. Blair Rollins was not at school on March 6th. Blair Rollins has not been located since March 6th. He practically disappeared. Blair Rollins also has a similar build to that of the figure seen in the Ring video cameras. And Rollins also has a strong motive. These witnesses will discuss how Alex Cifuentes could have used the help of Blair Rollins to frame Avery Becker for the murder. But the prosecution only have a half-finished puzzle. So they can't look down all the alternate routes provided by the evidence. I'm asking you, the jury, to look for all of the discrepancies in the prosecution's case, to look for all of the holes in this puzzle that were filled with faulty and incoherent evidence that came from a rushed investigation. The prosecution's experts are absolutely incompetent. Detective Jordan Markowitz accepted unverified screenshots of possibly fake text messages and has even brought them to court today. Meanwhile, crime scene reconstructionist Kyle Kuzak lost track of key photos for their investigation. They have based conclusions to this case off evidence that they don't even have. Today, the prosecution holds the burden of proof. This means that to pass a guilty verdict, you, the jury, cannot hesitate in your decision that Avery Becker is guilty of murder. But the prosecution only has a half-finished puzzle, so they cannot logically make any conclusions as to who committed this crime. You must have some reasonable doubt to who committed this crime by the end of today. I believe that you won't hesitate to call for the innocence of Avery Becker, because the prosecution only has a half-finished puzzle. It is in your hands to make the right verdict. Not guilty. Thank you.
Are people ready to call their first witness?
Yes, Your Honor. The people call Detective Markowitz to the stand. May I proceed, Your Honor?
May.
Detective Markowitz, please introduce yourself to the jury.
Good afternoon. My name is Jordan Markowitz. That's Markowitz.
Let's talk about your professional career. What do you do for a living?
Currently, I'm a homicide detective with the Denver Police Department.
How long have you been on the force?
I started my career with the DPD about 13 years ago, and I've been a detective exclusively for the past 7 years.
Over those 13 years, what skills have you acquired?
I've grown and developed many skills, especially skills concerning cell phones and forensic data recovery.
What does that mean?
This means I have the ability to acquire and decipher cell phone data, cell tower data, and the skill to use forensic software such as the Celebrite system.
Tell us about your specialized training.
Besides attending the basic police academy, I also attended the American Academy of Law Enforcement.
Did you receive any certifications?
Yes, sir. I was certified after taking a class while attending the American Academy of Law Enforcement that specialized in cell phone technology and forensic data recovery.
And how many times have you used this training and those skills you mentioned in your career?
I have downloaded and interpreted the contents of hundreds of phones and obtained and analyzed cell tower data in over 50 cases.
Your Honor, the people request the court to recognize Detective Markowitz as an expert in cell phone technology, forensic data recovery, and general police investigation.
Does the defense have any objection or voir dire?
No objection, Your Honor.
Detective will be so tendered. You may proceed.
Detective Markowitz, how did you begin your investigation?
I began my investigation. So actually, I start any investigation by removing any personal bias that I may have. As an experienced detective, it is crucial that I remove myself and any personal bias that I may have. So it is my job to follow the evidence and go where it takes me.
All right, let's talk about the beginning. March 6th. What happened that day?
That day, I was dispatched to 444 South Flower Street near Broomfield, Colorado. I arrived at approximately 1400 hours.
Upon arriving at the scene, what did you discover?
I found a Caucasian male, approximately 50 years old. He had been stabbed 1 centimeter below his left inferior scapular angle, just below his left shoulder blade, and had died of exsanguination, bleeding out.
How did you begin your investigation of the scene?
I began my investigation of the scene by working backwards. After examining the victim, I found that there was a trail of blood droplets leading back to the kitchen. I followed them and then investigated the kitchen.
What did you find in the kitchen?
In the kitchen, I found several relevant pieces of evidence. There was a chair knocked over, a broken plate, a knife drawer open, a knife missing from the knife block. This evidence clearly indicated that a struggle had occurred.
After investigating in the kitchen, where did you go?
After investigating the kitchen and clearing the inside of the house, I began looking around the outside of the house for evidence.
What did you find on the outside of the house?
I found 3 different Ring security cameras, one at the front door, one at the side gate, and one at the back door.
What can be seen on these Ring videos?
In these Ring videos, you can see someone wearing a mask, a hoodie, and gloves approach the front door of Mr. Brackman's home. They try to enter but are unsuccessful, so they move around through the side gate to the back door where they are able to unlawfully enter.
All right, let's talk about how you found the person in those Ring videos. How did you begin your investigation of possible suspects?
I began my investigation of possible suspects by downloading and analyzing the contents of Mr. Brackman's phone. I discovered that he was involved with mock trial at Colorado High School. Judging by the number of emails and texts he received about it, he was extremely involved. Through this involvement, I was able to get in touch with one of the members of the team, Alex Cifuentes.
What did you learn from Alex Cifuentes?
After a call and an interview with Ms. Cifuentes, I found out that the defendant had recently vandalized Mr. Brackman's car and was removed from the team for it. Then, in an attempt to get back on the team, the defendant texted Ms. Cifuentes asking for help.
Detective Markowitz and Mr. Winton, do you have Exhibit 14 in front of you?
Yes, sir, I do.
What is Exhibit 14?
This is a copy of the screenshots I was provided with by Ms. Cifuentes of the text sent by the defendant.
Are these a fair and accurate copy of the screenshots that you received?
Yes, sir, they are.
Your Honor, the people request that Exhibit 14 be admitted to evidence for its accuracy and authenticity have been shown.
Any objection or voir dire from the defense?
Yes, Your Honor. I would object hearsay to the text messages themselves, as well as the contact name of Avery Becker. I would also object authenticity, as the authenticity of this document has been brought into question. This would also violate Rule 1002 as this is not the best evidence. The best evidence for this piece of evidence would be the defendant, or sorry, Ms. Cifuentes' phone rather than the screenshots of the phone. And I would also object more prejudicial than probative, as there is very little probative value to this evidence because there's very little probative value to this evidence, as Detective Markowitz never actually saw the screenshots being taken place and never actually analyzed the phone. Therefore, we don't know if they have been altered, and the prejudicial effect of this evidence far outweighs any probative value.
I've heard 4 rules of evidence there: hearsay, authenticity, 1002, best evidence, as well as relevance, more prejudicial than probative. Are those the 4 grounds that you're objecting under?
Yes, Your Honor.
I'm actually going to handle that relevance first, because relevance is a threshold matter. So what is the people's position on the relevance of this evidence?
Your Honor, these screenshots are highly relevant. This shows and proves the defendant's intent to commit criminal mischief.
Does the defense have a response?
Yes, as it refers to the more prejudicial and probative argument I brought up, again, the prejudicial effect of this evidence far outweighs any probative value. The prejudicial effect being that we don't actually know if these were the exact screenshots that were on Mr. Cifuentes' phone. And because there was never an analysis of the phone, these could have easily been doctored, and we don't know whether or not that took place.
So I heard some authenticity argument there. Do the people have any specific response to the more prejudicial than probative element of relevance? We'll talk about authenticity later, but do the people have a position on whether these text messages are more or less prejudicial versus probative?
Yes, Your Honor. The probative value of these text messages is not substantially outweighed by the prejudicial effect.
Having reviewed the evidence as well as the rules of evidence, I am going to agree with the people that these messages are relevant and that they are not more prejudicial than probative. Let's now talk about authenticity, because that is what the defense turned to next. Do the people have a response to the authenticity objection?
Yes, Your Honor. Pursuant to Rule 901B1, this is what Detective Markowitz claims it is, and he's testified that these are the screenshots of a text conversation between Alex Cifuentes and the defendant.
Does the defense have any final argumentation?
Allow me one moment to pull up the exact rules of evidence for 901. Your Honor, it may be true that the witness claims that this is what it appears to be. However, there is a genuine question about the authenticity of this exhibit raised by the defense, as it is the defense's theory that Ms. Becker did not in fact write these texts. And because Detective Markowitz at no point actually used the Celebrate system that he mentioned to examine Mr. Cifuentes' phone, we don't know whether or not these texts were doctored at all, and that is where the authenticity objection comes from.
On that basis, I believe that's better handled by cross-examination and in closing statements. I deem this evidence to be authentic, or at least to be not admissible, or admissible as authentic, of screenshots sent to the detective by one of the witnesses. Relatedly, let's move on to the best evidence objection. Do the people have a response that this material is inadmissible because of Rule 1002?
Yes, Your Honor. This does not fall under the best evidence rule. The requirement of the original is required to prove the contents, but we are not using this to prove the contents, Your Honor.
Okay, does the defense have a response to that?
Your Honor, if the prosecution is not using this evidence for the contents of the text messages, then I would again re-raise my relevance objection, as there's no relevance to this evidence if they're not using it for the contents of the text messages.
May I respond, Your Honor?
Yes, I was going to say, can you give me an offer of proof, or what is your intent with these text messages?
I misspoke, Your Honor. Pursuant to Rule 1004A, the originals were lost and not by the proponent in acting in bad faith. Therefore, this does not fall under the best evidence rule.
Does the defense wish to be heard on 1004A?
Your Honor, the original was not actually lost before this evidence was taken and observed. The detective had more than enough opportunity to examine the actual physical evidence, that being Mr. Cifuentes' phone. And because of this, this does not fit the admissibility of other evidence. And it also goes against 1003, admissibility of duplicates, as this is a duplicate of the evidence and there is a genuine question being raised about the authenticity of this exhibit again.
As I previously ruled, the authenticity is appropriate to discuss on cross-examination. I do believe that 1004A is applicable here, as the originals have since been lost and thus are unavailable as evidence. Thus, under the best evidence rule, this evidence would be admissible. Finally, hearsay. And we have hearsay to both the contents of the messages as well as the contact name on the screenshot. Do the people have a position on the hearsay element of this objection?
Yes, Your Honor. As it relates to the statements made by the defendant in these text messages, this is not hearsay. Pursuant to Rule 801 D2A, this is a statement made by a party opponent. In regards to the statements made by Ms. Cifuentes in these text messages, we're not offering these for the truth of the matter asserted, rather the effect it had on Ms. Becker.
Do the defense have a response to effect on the listener as well as not hearsay party opponent?
Your Honor, the objection, or we have no response to them not including Mr. Cifuentes' text. However, we do still believe that the contact name of Avery Becker is hearsay, as it is an out-of-court statement being used to prove the truth of the matter asserted. The matter asserted being, in fact, that the green texts are from Avery Becker.
Do the people have any final response to the hearsay specific to the contact name Avery Becker on the text message screenshots?
Yes, Your Honor. Pursuant to Rule 803.1, this is a present sense impression. When Ms. Cifuentes first received Ms. Becker's contact information, she made a statement, this written assertion describing the condition of that phone number.
And on that basis, do the defense have any final parting thoughts?
Your Honor, as Mr. Cifuentes as Mr. Cifuentes received these texts after the contact was made, this does not fit the rule present sense of impression, as they were not actively making the name every single time they received a text. And because it was already in place, this does not fit the rule 803.1.
Okay, thank you. I appreciate the argumentation by the attorneys. I am inclined to find these text messages to not be hearsay under opposing party statements, effect on the listener, as well as present sense impression. I will note that because the coach's statements are being offered only as an effect on the listener, they cannot be used as substantive evidence in closing statements. Based upon my rulings on the defense's 4 grounds to object, I'm going to overrule the objection and admit exhibit. Let me get the exhibit number right. I believe this is exhibit 14 into evidence.
Your Honor, permission for Ms. Sayers to publish this to the jury?
Yes.
Detective Markowitz, on these text messages, what specifically furthered your suspicion?
There are 2 texts in particular that caught my eye. The first one being, well, if he's upset about his car, then he's going to be really upset when he sees what I do to his house. The second one being, I'm going to wait until he's at work, then break in and trash it. Of course, in reference to the home of Mr. Brackman.
Thank you, Ms. Sayers. Detective Markowitz, other than that, what else led you to suspect the defendant?
Upon further examination, call detail records provided information about the location of the defendant's phone on the day of March 6th.
What are call detail records?
Call detail records, or CDRs, are accurate records when phone calls or text messages were sent and received to a specific phone.
Detective Markowitz and Mr. Winton, direct your attention to Exhibit 16.
Yes, sir.
Detective, what is Exhibit 16?
This is a copy of a map that I have overlaid with cell towers and their arcs.
Is this a fair and accurate copy of the map you overlaid?
Yes, sir, it is.
Your Honor, the people request Exhibit 16 to be admitted into evidence for its accuracy and authenticity have been shown.
Any objection or voir dire from the defense?
Yes, Your Honor. I would object more prejudicial than probative, relevance, and hearsay. My relevance objection goes to the fact that the cell towers don't necessarily connect to the cell phone, or excuse me, the cell phone does not necessarily connect to the tower that it is closest to. Rather, it connects to whichever tower is less busy. As for my more prejudicial than probative, it is the defense's theory that Ms. Becker was not in possession of her phone, and therefore this evidence is substantially prejudices the jury against my client, Ms. Becker, and provides no probative value, as Ms. Becker was not in possession of her phone. And as for the hearsay, the locations of like Mr. Brackman's home and Ms. Becker's home, as well as the dotted line that Mr. Markowitz has drawn, are all out-of-court statements being used to prove the truth of the matter asserted. The matter is asserted being that those locations are in fact what they claim to be, and that the dotted line is in fact the route that Ms. Becker took.
Okay, turning back to the people, let's handle these again, each in turn, though I want to consolidate the relevance objections, both simple relevance as well as more prejudicial than probative. What is the people's position on the relevance of this evidence?
Your Honor, this is highly relevant once again. This proves Avery Becker's whereabouts, or her phone's whereabouts, during the time of the murder. The probative value of that is not substantially outweighed by the prejudicial effect.
I'm inclined, does the defense have any final response?
Yes, Your Honor. The prejudicial effect being that it would substantially prejudice the jury against Ms. Becker, and there's very little probative value, as the cell tower data cannot accurately determine whether or not Ms. Becker was in possession of her phone, and because the defense believes that Ms. Becker was not in possession of her phone, this is substantially more prejudicial than probative.
I'm inclined to agree with the people on this matter. Once again, that this is something best addressed on cross-examination by the defense. Turning to the hearsay element of this objection, that various elements were added to this exhibit, specifically the dotted line, the location of Coach Becker's home, and the location of the cell phone towers are out-of-court statements. Do the people have a response to hearsay?
Yes, Your Honor. This is being offered as a demonstrative for demonstrative purposes. It would be no different than Detective Markowitz testifying that the cell tower was here, here, and here, and Blair Rollins and Avery Becker's home was here and here, and the victim's home was here. For that reason, it's not hearsay, Your Honor.
Does the defense have a response to not hearsay? These are not being offered for the truth of the matter. They are being offered for demonstrative purposes only.
Your Honor, as for the demonstrative, they're more than welcome to actually take the map and show this is the cell tower, this is the route that Ms. Becker could have taken. All of that, however, the evidence not being a demonstrative itself, rather just having all of that already laid out on it, makes this not a demonstrative and makes it hearsay.
May I respond to that, Your Honor?
Yes.
Detective Markowitz has testified that he prepared this statement or this map for trial. Therefore, the locations on that map are being used for a demonstrative.
So on that basis, I will allow the map to come in, though these hearsay elements, the additions that have been made to the map, will not be considered substantive evidence. They are demonstrative only and should be thus appropriately used by attorneys in closing arguments and would be grounds for an objection if they are mischaracterized as substantive evidence.
Yeah, sure.
On that basis, the objection is overruled. Exhibit 16 is deemed admissible.
Permission for Ms. Sayers to publish this to the jury.
Yes, with additional jury instructions that the additions to the map are not to be deemed substantive evidence in of themselves.
Yes, Your Honor. Detective Markowitz, can you explain what's on this map?
On this map, I located the position of 3 different cell towers: cell tower 1227-3, cell tower 1191-1, and cell tower 1197-1.
And can you explain the location of the pins on the map?
Yes. Through my investigation, I found out the addresses of these 3 people's homes. Miss Becker's up towards the top of the map, Blair Rollins just to the left of that, and Mr. Brackman's down in the 3rd cell tower.
All right, Detective, what does this map prove?
Looking at this map, in addition to just the tower number, I also included the time. The first ping was made at 12:47 at the tower at the top of the map by Centura Health, the tower covering the defendant's home. The second ping made at 12:55 at the tower in the middle of the map by West Flatirons Crossing Drive, pings at 12:55. Then the third tower, the one covering Mr. Brackman's home, pings at 3 different times: 13:05, 13:06, and 13:17, right at the time of the murder.
What does the phone pinging 3 times at the victim's home prove?
This means that it would be extremely likely that the phone was near that cell tower because of the repeated connection.
How accurate are these call detail records?
While they are not 100% accurate, they are highly accurate, as cell phones use an extensive algorithm to connect to the tower that provides the best services. Only in instances of extremely high cell tower traffic would a phone not connect to the closest tower. However, in this case specifically, because the phone connected to the same tower on 3 separate occasions, this clearly indicates that the phone was in the vicinity covering Mr. Brackman's home.
Thank you, Ms. Sayers. Detective Markowitz, how big of a role did the call detail records play in your arrest of the defendant?
They were not the deciding factor. In fact, they were just one piece in my completed puzzle.
Let's talk about Avery Becker. Let's talk about your conclusions. Have you reached an expert conclusion in today's case?
Yes, sir, I have.
What is that conclusion?
In my expert opinion, first the intruder tried to enter the front door, but they were unsuccessful, so they moved around the back door where they are able to unlawfully enter the home of Mr. Brackman. Then events ensued that ended with Mr. Brackman being stabbed in the kitchen before moving, falling at his front door, and bleeding out.
Why is that your conclusion?
I concluded that because of the totality of the evidence at the crime scene, the knocked over chair, the knife missing from the knife block, the open knife drawer, the broken plate, the Ring camera systems, and where the victim lay, all led me to this conclusion.
Who can you conclude the intruder was?
I can conclude that the defendant, Avery Becker, was the intruder in this case. Looking at all the evidence, especially the texts and the towers, allowed me to make this conclusion.
Can you identify the defendant here today?
Yes, sir, I can. She was the one who you saw in introductions with dark hair, a white blouse, and a black blazer.
Thank you, Detective. Your Honor, I have no further questions at this time.
Thank you. Defense, do you wish to cross-examine this witness?
Yes, Your Honor, allow one moment while I adjust my camera. Good afternoon, Detective Markowitz.
Good afternoon.
Let's talk about what you claim as your completed puzzle. You never found any DNA evidence at the scene of the crime?
Sir, because of the gloves and the mask that covered any DNA that would have came out of the mouth, there was no DNA left at the scene.
So that's a yes to my question. There was no DNA.
No DNA from the defendant, no.
And there were no fingerprints found at the scene, were there?
As I just said, they were wearing gloves. This would have prevented any fingerprints from being left.
And there were no eyewitnesses?
Unfortunately, there were not eyewitnesses. This would have made the case a lot easier if there were.
So let's talk about some of the evidence that you think you have. Let's talk about the Ring video camera. You claim this is evidence that Ms. Becker broke in?
First of all, I don't think I have any evidence. I do have evidence, and I don't claim anything. The evidence speaks for itself.
Is that a yes or a no to my question? You believe that the Ring video camera is evidence that Ms. Becker broke in?
It is part of the evidence that showed the intruder coming to the house. All that was concludable from the Ring videos.
Objection, non-responsive. I have asked a properly framed yes or no question, and the witness has consistently gone far outside the scope of my question. And as this is a timed question, and as this is a timed competition, if the witness would like to go into more detail explaining their answer, they can do so on their own time during redirect.
Yes, I would direct the witness to please respond only to the questions that are being asked.
I ask that their last testimony be stricken from the record.
I believe as of now, their response should remain on the record, and we will continue. Please, witness, respond only to the question that's being asked.
Yes, Your Honor. So yes or no, you claim that the Ring video camera is evidence that Miss Becker broke it?
Yes, it is.
Now, the suspect in that video was wearing a disguise, correct?
Yes, sir, they were.
And Miss Becker wasn't in possession of such a disguise, was she?
I have no way of knowing whether the defendant was in possession of that disguise.
You didn't look for her. You didn't look at her house?
Even if the defendant had that disguise, they could have gotten rid of it after the murder.
So that's a yes to my question. You did not search the defendant's residence?
No, sir, I did not.
Now, the videos do not have a timestamp on them, do they?
No, sir, they do not.
So you don't know exactly when the videos took place. Is that correct?
I do not know the exact time that the videos took place.
Now, let's talk more about your investigation. You claim that the biggest break in your case was talking to Alex Cifuentes? Yes,
that was the first lead that I followed up on.
However, you interviewed Avery Becker and Taylor Perkins before you interviewed Alex Cifuentes. Is that correct?
No, sir, I did not interview Avery Becker nor Taylor Perkins.
It is your statement today in court that you at no point interviewed Avery Becker or Taylor Perkins?
No, sir, that is not in my statement.
I'm sorry, I'm a bit confused. Yes or no, is it your statement here today in court that you did not interview Ms. Becker or Ms. Perkins?
I was not allowed to interview Miss Becker, and I did not interview Taylor Perkins.
Now, you were sent screenshots of texts that you claim were sent by Ms. Becker. Is that correct?
Yes, sir, I was.
However, you waited a full 3 months after the crime took place before you received these screenshots.
No, sir, they were sent to me as soon as the day after, actually, I interviewed Alex Fuentes.
But the day after you interviewed Alex Fuentes was a full 3 months after the crime took place.
No, sir, it was not.
Now, let's talk about Blair Rowlands. You never interviewed him, Blair Rowlands was a suspect in today's case.
Yes, sir, he was.
However, you never attempted to locate Mr. Rowlands.
He was unable to be contacted throughout my investigation of this case, and he is still missing today.
You never searched his residence?
No, sir, I did not include that in my statement.
You never spoke to his father about where he could be?
No, sir, his father was in jail. I could not contact him.
You could not contact his father in jail. That's your statement, is it?
I was unable to. I did not contact his father in jail. No.
Now, let's talk about Ms. Becker's phone. You claim that the phone was near Mr. Brackman's home.
Yes, sir, that is what the CDRs show.
Well, let's talk about that CDR. It cannot show whether or not a person is in possession of her phone?
No, sir, it cannot. It only shows the location of the phone.
It also doesn't even show a pinpoint location, does it?
Not pinpoint, however, a location.
It only shows which tower it connected to?
Yes, sir.
Now, let's finally talk about the alibi that Ms. Becker has. You never investigated this alibi, did you?
No, sir, I did not.
Thank you, Your Honor. No further questions.
Any redirect from the people?
Yes, Your Honor. Detective Markowitz, why wasn't there any DNA or fingerprints left at the scene?
As seen in the Ring videos, the defendant or the intruder was wearing gloves, a mask, a hoodie. There was no DNA left at the crime scene to even collect.
And why didn't you find the mask and the hoodie that the defendant wore?
Sir, even if I were to investigate the defendant's home and look thoroughly, it would have been likely that they had gotten rid of it.
Let's talk about the time of the Ring videos. Can you tell us about that and how it relates to the time that the murder took place?
The murder took place at approximately 1:27. As seen by the cell tower arcs and the time it pings, they also occurred at that time. It was my conclusion that these were the same time, that the intruder coming to the house with the phone was the same time that the Ring videos occurred.
Let's talk about the day you interviewed Ms. Cifuentes. When did you interview Ms. Cifuentes?
I interviewed Ms. Cifuentes as soon as I could after the murder happened, not 3 months later.
And did she send you the text messages 3 months after the murder?
No, sir, she did not.
When did she send them to you?
The very next day.
Thank you, Detective. Your Honor, I have no further questions.
Does the defense have any recross based upon that redirect?
Briefly, Your Honor. You have no evidence showing exactly when the Ring video took place. Is this correct?
No evidence of exactly when. There was not a timestamp on the videos.
And you did not at any point attempt to search Ms. Becker's residence to find this disguise?
No, sir, I was actually barred from doing so.
You couldn't receive a warrant to search the residence?
I attempted to, but was unable to receive a warrant for anything except for her phone number.
Thank you, Your Honor. No further questions.
Do the people wish to do a redirect based upon that recross?
No, Your Honor.
Can this witness be excused?
Yes, Your Honor.
Okay, the witness may step down.
Thank you, Your Honor.
Do the people have any additional witnesses that they would like to call at this time?
Yes, Your Honor. The people call Kyle Kuzak to the stand. Good afternoon, Mr. Kuzak.
Good afternoon.
My name is Madeline Proctor. Please introduce yourself to the jury.
My name is Kyle Kuzak, last name spelled K-U-Z-A-K.
Mr. Kuzak, what do you do for a living?
I am a Colorado Bureau of Investigation certified crime scene reconstruction investigator. For simplicity's sake, we're known as CSRs.
What does being a CSR entail?
It's a very interesting job, Ms. Proctor. Crime scene reconstruction is an interdisciplinary field involving biology, say when looking at bodies or blood cast off, and physics and ballistics when examining shell casings or bullet holes. CSRs like me use this specialized knowledge to help the police investigate crime scenes, potential crime scenes.
What do you mean by potential crime scenes?
I deliberately use the word potential because the evidence doesn't always point to a crime. Sometimes my investigations reveal that what might look like a crime scene at first glance was actually a result of a fatal accident where no crime was committed.
So,
Check, Your Honor. Relevance.
Response, Your Honor?
Yes.
So under 401, any evidence that has a likelihood to make a fact more or less likely is relevant, and the fact that not all of his crime scenes lead to a crime having been committed and his reconstructions makes it directly relevant as it goes to his credibility as an investigator and reconstructionist.
Response, Your Honor.
Yes.
That fact does not have any relevance to Mr. Kuzak's qualifications, and it does not have any relevance to this case itself, as this case has already been confirmed to be a crime scene.
Response, Your Honor?
No need. I agree that this is relevant to the witness's qualifications, as well as providing the jury appropriate context about the witness's background. So I will allow it. Obviously, if it gets far extreme, a relevance objection at that time would be appropriate, but thus far, I believe that this is appropriate context for the jury members to hear. You may proceed.
Yes, Your Honor.
So, Mr. Kuzak, you were saying that a crime has not always been committed in your reconstruction. What sort of crimes do you work on?
Well, there's actually no one single kind of crime that I do work on. I've worked on a multiplicity of cases, everything from property crimes like home invasions and burglaries to violent crimes like homicides, domestic violence cases, and armed robberies.
And in your work, who do you work for?
Currently, I'm working with the Denver Police Department as a civilian employee. I've been working with them for the past 3 years.
Did you work for anyone else before that?
Yes, actually I have over 19 years of experience in the field working for different police departments in Colorado.
Your Honor, at this time, the people request the court to recognize Kyle Kuzak as an expert in the field of crime scene reconstruction. Pursuant to Rule 702, his skill, knowledge, experience, education, and training have all been shown, and his testimony will assist the jury in understanding the facts of today's case.
Any objection or voir dire from the defense?
There is no objection, Your Honor.
On that basis, Kyle Kuzak will be tendered as an expert in crime scene reconstruction and may testify pursuant to being an expert witness.
Mr. Kuzak, in your reconstructions, is there a method that you typically follow?
I, along with all other experts in my field, use a tried and true process, Ross and Gardner's 5-step method.
Tell us about Ross and Gardner's method.
It's a 5-step process centered around analysis of evidence. In the first step, recognition, I map out the basic facts of the case, as well as the witnesses involved. In step 2, collection of evidence, I work alongside the police to find evidence. Afterwards, for step 3, I start putting that evidence together to form probable event segments. In step 4, I construct a basic theory about the case using my event segments. And then, of course, in step 5, I do my work, reconstruction.
Let's talk about how you applied that method in this case. How did you How did you go about step one?
For recognition, I documented not just the witnesses involved, but also all the evidence ID numbers. This is so for ease of access.
What about step two?
Step two would be the collection of evidence. I was able to view the crime scene firsthand on the day of the murder. I worked after the police forensics team saw the crime scene. I came in and reviewed it myself.
And how did you analyze that evidence?
I analyzed that evidence as part of step three of my process. I expanded organizational framework from step one and used the scientific process to try to find event segments based on that evidence.
All right, and what evidence did you use in your reconstruction?
There was evidence all over the bottom floor of the house. Firstly, there were scuff marks and a knocked over chair by the back door. In the kitchen, there was a broken plate, a knife block with a knife missing, and an open knife drawer. As I moved further through the house, I saw blood cast off on the walls and ceiling. And then by the front door, there was Mr. Brackman's body and a bloody knife.
Let's walk through your reconstruction a bit. So starting with the victim's body and the bloody knife, what did that evidence tell you?
In combination, these pieces of evidence showed me three important facts about today's case, namely that Mr. Brackman was stabbed, that he died of exsanguination after he pulled the knife out of his back, and that the knife found by him was used to kill him.
Do you know where the knife came from?
It is my conclusion that the knife came from the knife block. However, it is also possible that it came from the open knife drawer.
Mr. Kuzak, does it matter whether the knife came from the block or the drawer?
Personally, to me, it does. I'm very meticulous about my reconstruction. However, what really matters in today's case is that either way, the knife came from inside the house.
And why does that matter?
The fact that it came from inside the house shows that the intruder did not bring a knife or plan to use a knife. This was key in my determination that this was a planned burglary gone wrong and not something more sinister.
I see. So now we're in the kitchen. What did the evidence there show you?
So in the kitchen, there was a knocked over chair, a broken plate, and scuff marks near the back door. Independently, these pieces of evidence don't show me much. However, together, they reveal that an altercation occurred between the intruder and Mr. Brackman.
Tell us about that altercation.
Mr. Brackman attempted to stop the intruder from entering the home, creating the scuff marks on the floor. As they fought in the kitchen, they knocked over the chair and broke the plate.
You also said you received some evidence from the police. What was that?
Yes, that is correct. Detective Markowitz sent me footage from the Ring security cameras around the property.
And what did the Ring security system show you in your reconstruction?
They showed me the height and build of the intruder's progression around the house, and the fact that the intruder was even picked up on camera reinforced my conclusion that Mr. Brackman was alerted by the alerts from the Ring security system.
All right, Mr. Kuzak, let's skip ahead to your final step, reconstruction. Were you able to reconstruct what happened?
Yes, I was.
Mr. Kuzak, reconstruct March 6th for us. What happened?
An intruder walked up to the front door of Mr. Brackman's residence. Finding it to be locked, he moved through the side gate and into the back door. Along the way, the free Ring security cameras picked them up and warned Mr. Brackman. Mr. Brackman rushed to grab an offensive weapon, first opening a drawer and then grabbing a knife out of the knife block. He fought with the intruder. When the intruder entered during this fight, the knife ended up in his back. He died after he removed it and walked to the front door.
You said earlier that the evidence does not always point to a crime having been committed. Does that apply here today?
No, in this case, the evidence clearly points to a crime, specifically that Mr. Brackman's death was the result of a burglary gone wrong.
Thank you, Mr. Kuzak. Your Honor, I have no further questions at this time.
Thank you. Does the defense wish to cross-examine this witness?
Yes, Your Honor. Before I begin, can I please readjust my camera?
Yes, of course.
May I inquire a brief time check before I begin?
Yes, the defense has 14 minutes and 23 seconds remaining.
Thank you, Mr. Hernandez. May I proceed?
Good night.
Hello, Mr. Kuzak.
Hi, Mr. Seitzel. Good afternoon.
Good afternoon. Let's start with the beginning of the crime. You testify that Mr. Brackman was aware of the intruder.
Yes, the evidence at the crime scene does indicate this.
And that Mr. Brackman was alerted by Ring video cameras that were placed around the house.
That was my conclusion. However, if he wasn't, he was probably alerted by the opening door.
So we don't know if those Ring cameras had push notifications turned on his phone.
We do not definitively know, which is why I used the entirety of the evidence at the crime scene to determine exactly how Mr. Brackman was alerted.
But a push notification could have given us a timestamp for when this break-in took place, correct?
I believe so. However, I'm not very familiar with exactly how notifications work on cell phones.
But because no one in the prosecution investigated Mr. Brackman's phone, we do not have a timestamp for when this break-in took place, correct?
No, I actually believe that the contents of Mr. Brackman's phone was downloaded and analyzed with the Cellbrite system. That is how Detective Markowitz, one of the things that led Detective Markowitz to mock trial.
But Detective Markowitz never found any timestamp or push notification for these Ring videos.
To my knowledge, he did not.
Let's move on. You testify that when Mr. Brackman was alerted by this intruder, he grabbed a knife from either a knife block or a knife drawer.
I believe he grabbed it from the knife block, from the slot in the upper left-hand corner.
And then after Mr. Brackman grabbed the knife from the knife block, the intruder gained this knife from Mr. Brackman in a struggle, correct?
Yes, at some point in the struggle.
But you barely have any evidence to how this struggle happened, or if it happened at all.
I have plenty of evidence about how it happened. I have the knocked over chair, I have the broken plate, I have the scuff marks, and the fact that Mr. Brackman was even stabbed.
Let's start with that broken plate that you mentioned. Your Honor, at this time I ask that my trial technician display Exhibit 9 solely for the purposes of identification, as it has not been admitted into evidence so far.
Yes, you may display to everyone but the jury, the constructive jury.
Mr. Cusack, you recognize this picture of the broken plate on the floor, correct?
Yes, I do. I saw the broken plate firsthand.
And this picture is fair and accurate to the best of your knowledge.
It is.
Your Honor, at this time I move to admit Exhibit 9 into evidence.
Do the people have any objection or voir dire on Exhibit 9?
No, Your Honor, the people have no objection to Exhibit 9.
Exhibit 9 is admitted into evidence.
May I publish to the jury?
You may publish to the jury at this time.
Mr. Cusack, we can agree that there is a broken plate on the floor, correct?
Yes, that is shown in this photo.
Yet everything else in the photo, the carpet, the table, the chair, the placemat, and the napkin are all in order, correct?
That is correct. They didn't fight on top of the table.
But you testify that a violent struggle came through this area, correct?
Through or alongside. I said a struggle did occur in the kitchen.
Yet in this photo, there's only one broken plate on the floor and everything else is in order.
Yes, in this photo specifically, taken at this angle.
Thank you, Mr. Hernandez. You can take down the exhibit. Let's move on to the scuff marks that you mentioned. You were never able to date exactly when these scuff marks were made?
Not exactly, no. However, using the rest of the evidence at the crime scene, I can determine that they were likely made in an altercation between Mr. Brackman and the intruder.
So to answer my question, you were not able to date when the scuffs were made?
Independently, no.
And you were not able to find any physical evidence tying the scuff marks to the rest of the crime, correct?
No, the knocked over chair and a broken plate tied the scuff marks to the rest of the crime. Again, they showed that an altercation took place. That is physical evidence that connects the scuff marks to the rest of the crime.
But there's no physical evidence that proves that the scuff marks were made by either Mr. Brackman or the intruder.
No, I didn't literally see Mr. Brackman or the intruder scuffing the floor.
Your Honor, at this time, I ask that my trial technician display Exhibit 17 solely for the purposes of identification, and they will not be shown to the constructive jury.
Yes, you may proceed.
Mr. Hernandez, may you please display Exhibit 17?
Counsel, it would appear that Exhibit 17 is unavailable to me at this time.
Your Honor, at this time, then I just request that Exhibit 17 be constructively displayed to this witness.
That's okay. Exhibit 17 is being constructively displayed to this witness, and this witness may pull up Exhibit 17 in front of them.
Thank you, Your Honor.
Ms. Cusack, just let me know when you're ready.
Of course. Yes, I have Exhibit 17 pulled up.
Okay, good. You recognize Exhibit 17 as your witness tracking sheet, correct?
Yes, I do.
And this exhibit is fair and accurate to the best of your knowledge.
It is my witness tracking sheet, yes.
Your Honor, at this time, I ask that Exhibit 17 be published into evidence or admitted into evidence.
Do the people have any objection or voir dire on Exhibit 17?
Yes, Your Honor, this is hearsay. This is an out-of-court statement being offered for the truth of the matter asserted under 801, and under 802, that is unadmissible.
Response, Your Honor?
Yes.
This is a first, this is a regularly kept business record. Second, this is not being used to prove the truth of the matter asserted. This is being used to compare two separate statements that have been given by Mr. Cusack in the past.
May I respond, Your Honor?
One moment. But yes, you will be able to respond. Let's handle the business record first. So why don't you respond to the exception that this is a admissible or an exception to hearsay applies to wit a business record.
Yes, Your Honor. So this exhibit is not a business record as it is being used, as it has more than just a regularly conducted account of what had occurred, like a receipt. This has his entire investigation mapped out, including opinions and records. That is not the same thing as a regularly conducted business record. So the foundation has not been sufficiently laid for that exception.
Does the defense have any final argumentation about this is not a business record admissible under the business record exception to hearsay?
May I have a brief moment to pull up the rules of evidence?
Yes, you may.
Your Honor, pursuant to Rule 703, an expert witness does not have to rely on otherwise inadmissible evidence if it has probative value to the case or their opinion.
Response to that, Your Honor?
Yes, you may.
Under 703, an expert may rely on otherwise inadmissible evidence, like hearsay. However, that does not mean that the exhibit itself can come in.
That's yes, you may respond.
I still stand by my original response that this is, again, not hearsay, as it is not being used to prove the truth of the matter asserted. This is being used to compare two separate statements from Mr. Cusack, not to prove any truth.
Response to that, Your Honor?
Yes, you may.
If it is being used to compare statements by parties in this case, then it is in fact being offered for the truth of the matter asserted. So that would still be hearsay under 801.
Response, Your Honor?
Yeah, I am inclined to agree with the people on this matter. The appropriate foundation has not been laid for this to be a business record. Under Rule 703, it can be referenced by a testifying expert witness. That does not mean that the exhibit itself is admissible. If it is being used for impeachment purposes to show a contradiction of some type, the foundation for an impeachment has not been laid. If you wish to lay the appropriate foundation, it may become admissible at that point, but thus far that work has not yet been done. So the objection is sustained. Exhibit 17 is not admitted into the record.
May I consult my co-counsel on how to proceed?
You may.
Your Honor, I wish to lay more foundation as to the origins of this document and the fact that Mr. Cusack made this document himself, which would then make it admissible under 703.
You may proceed with your cross-examination in any manner that you deem appropriate. So continue with your line of questioning, Counselor.
Mr. Cusack, you mentioned before that you make witness tracking sheets and that witness tracking and evidence tracking is necessary for your investigation, correct?
Witness tracking and evidence tracking is necessary, yes. What spreadsheets I make exactly in each case does differ.
But you did make this spreadsheet for witness and evidence tracking for this case of Avery Becker.
Yes, specifically for this case.
Your Honor, I've laid proper foundation as to the fact that Mr. Cusack has created this document himself and that it is necessary it is admissible because it is the opinion of an expert witness under Rule 703.
Do people have any additional argumentation related to 703 at this time?
Yes, Your Honor, the people renew their objection to hearsay as it does not fall under the business record exemption. First, because it was not made at or about the time of the events that occurred. And second, because it is still including things that are outside of the regularly recorded business activities. So the foundation has not been laid that it is a regularly recorded business record.
A response?
Yes, if you would like to make a response to that.
I am no longer trying to admit it under the fact that it is a business record. I'm admitting it under that it is the opinion of this expert witness that he himself has testified to have made in the past regarding this case.
Response to that again, Your Honor?
No need. Once again, I find that under Rule 703, the witness may testify as to the contents of the evidence. An expert witness, is allowed to opine on facts or data that would be otherwise inadmissible. That does not mean that this evidence is somehow affirmatively admissible under Rule 703. So once again, the witness may testify about the contents of this evidence, but Exhibit 17 is not admissible at this time.
Yes, Your Honor. Mr. Cusack, let's talk about the contents of Exhibit 17. You mentioned 3 different suspects in this exhibit, correct?
Yes, that is correct. Blair Rollins, Avery Becker, and Alex Cifuentes.
Let's first talk about Alex Cifuentes. Alex Cifuentes is testifying today in court?
Correct.
Alex Cifuentes is testifying for the prosecution?
Yes.
Yet Alex Cifuentes is also a suspect in this crime?
Mr. Zeitel, the police considers everybody to be a suspect in a murder investigation. That's how those investigations are conducted.
Yet Alex Cifuentes is one of the 3 suspects that you chose to put in this witness tracking sheet.
I did not choose which suspects put into the witness tracking sheet. I was provided suspects by the police.
Let's move on to Blair Rollins. You do not know Blair Rollins' current whereabouts, correct?
I know very little about Blair Rollins.
No one in the police knows where Blair Rollins currently is?
To my knowledge, yes, he is.
Objection, Your Honor. Under 602, this is outside the knowledge of Mr. Kuzak. He has no direct knowledge of if any single member of the police department knows about Blair Rollins or their whereabouts.
Response to 602.
I'm not assuming that Mr. Kuzak knows where Blair Rollins is. I'm simply asking Mr. Kuzak if he knows anyone in the police force who knows where Blair Rollins is. Also, this is cross-examination, so it's proper testimony.
The witness may respond to any questions that he has personal knowledge of. You may proceed. The objection is overruled.
Yes, Your Honor. Let me re-ask my question. No one in the police, to your knowledge, knows where Blair Rollins currently is?
I cannot definitively say whether any one member of the police department knows where Blair Rollins is. No.
And in Detective Markowitz's direct examination, which recently occurred, Detective Markowitz mentioned that evidence was collected soon after the crime itself, and that that Taylor Perkins and Avery Becker were not interviewed.
No, they were not.
Yet, in Exhibit 17, you mentioned that Taylor Perkins and Avery Becker were interviewed in March.
No, Mr. Zeitzel, I do not. I say interview RPT, which can also mean that they were contacted for interview, but they declined their interview. The police is required to report this.
Yet, Detective Markowitz said that he was not able to interview either Taylor Perkins or Avery Becker. And in Exhibit 17, you do state specific stuff that Taylor...
Objection, Your Honor. This is cumulative. I mean, compound.
I do agree that that was a compound question. Counselor, please make sure that you're only eliciting one fact per question.
Yes, Your Honor. In Exhibit 17, you mentioned specific statements that Taylor Perkins made, correct?
Yes, I say provided statement. They provided a statement to the police, however, they were not interviewed.
So Detective Markowitz said that neither of these witnesses were interviewed and that they were not gain an alibi from those witnesses, but there is still a statement on this witness tracking sheet.
Yes, they provided a statement with information, however, they were not interviewed.
Let's move on to another problem in this case. You found blood splatter at the scene of the crime, correct?
It's blood cast off, to be specific. Yes, I did.
I apologize. Blood cast off. And you made conclusions based on this blood cast off?
Yes, every piece of evidence at the crime scene informed my conclusion. Every piece of the puzzle.
Yet we do not have any images or evidence of this blood cast off here today in court.
Not in court today, no. It is my understanding that the files were corrupted.
So the defense expert will not be able to see these images?
No, I do not believe so. However, I'm not sure. I'm not the custodian of these documents.
And
I do not know exactly when they were corrupted or who accessed them beyond myself, of course.
And the jury will not be able to see these images?
No.
Thank you, Mr. Kuzak. No further questions.
Do the people wish to have a redirect of this witness?
Yes, Your Honor. Mr. Kuzak, how big of a role did the blood splatter play in your reconstruction?
While they didn't help inform my conclusion, they only played a marginal role. They only reinforced conclusions I already had, such as the fact that Mr. Brackman was stabbed and died of exsanguination.
And did you see that blood splatter yourself at the crime scene?
Yes, I did. I saw it myself, and I also later saw the photographs that the police took.
And do you still have a conclusion for us on what happened on March 6th?
Yes, I do.
What is that?
My conclusion remains the same. Mr. Brackman's death was the result of a burglary gone wrong.
Thank you, Mr. Kuzak. Your Honor, I have no further questions.
Does the defense wish to have a recross on the basis of that redirect?
There will be no recross from the defense, Your Honor.
Can this witness be excused?
Yes, Your Honor.
This witness is now excused. Do the people have any additional witnesses that they wish to call at this time?
Yes, Your Honor. The people call Alex Cifuentes to the stand.
You may proceed, Counselor.
Your Honor, before the people proceed, I would like to bring to the court's attention that Hayden Clausen, who is the crossing attorney of this witness, was kicked out of the meet. So I ask that we take a brief pause until he is allowed back in.
Let's have all timekeepers pause at this time. I do see that Hayden is online. It seems that he's just unable to connect to audio. We may need to do a mobile setup for Hayden. And I'll remind all panelists to, are you online?
No, this is Marcus Winton. I am currently in contact with Hayden. He is saying that he's attempting to enter through his phone so that he may have audio and be able to proceed.
Okay, great. I will keep an eye out for him and admit him as soon as I see him. And just a reminder to panelists to please not score based on technical difficulties. Okay, I am admitting Hayden now. Hayden, can you please connect to audio and share your video and microphone? Hayden, can you hear me?
Yes.
Okay. Okay, Your Honor, please confirm when the timekeeper should start time again. It looks like we have Hayden up and running.
Timekeepers, you may start now. And you may proceed.
Good afternoon, Mr. Fuentes. My name is Feliciana Sayers. Please introduce yourself to the jury.
Hi, I'm Alex Cifuentes. That's Sifuentes.
Let's start with Avery Becker. How do you know her?
Avery and I were really good friends. We were actually on the mock trial team together. She got me to join when I was a freshman.
Let's talk about your mock trial team. What was Ms. Becker, how did Ms. Becker fit into your mock trial team?
Avery was a lawyer, but she would constantly show up late and unprepared.
How did this affect your team?
It caused us a lot of anxiety, especially going into important tournaments like regionals.
Now let's talk about Coach Mackenzie Brackman. Who was he to you?
Coach Brackman was an amazing guy. We both believed that working hard was the way to succeed. I actually think he saw a bit of himself in me at times. It's really sad knowing that he's gone. I just really miss him.
Miss Fuentes, I understand this is hard for you, but we need to continue. What was Coach Brackman and Miss Becker's relationship like?
It wasn't the best, to say the least. There's just a lot of tension, and they would argue almost every practice.
What was their biggest argument?
I would say their biggest one was after the regional tournament when Coach was just debriefing us, and when it became Avery's turn, he was telling Avery that what she did would be considered malpractice and she needed to be more prepared.
What was Miss Becker's response?
She stormed out of practice and took a marker and wrote Worst Attorney Award on Coach's car.
What was Coach Brackman's response?
He kicked her off the team, of course. He was a great attorney. Of course, he was going to have some issues when Avery vandalized his car, especially because it's illegal.
Now, Mr. Fuentes, let's talk about the text messages you received from Miss Becker. How do you know Miss Becker sent them?
Avery and I were good friends. We texted all the time. It was my phone, it was Avery's contact.
Your Honor, at this time, I request that Mr. Powell screen share Exhibit 14.
Mr. Powell may screen share Exhibit 14, constructively not showing it to the members of the jury yet.
Your Honor, Exhibit 14 has
It has been
previously
admitted.
been.
Yes, it is constructively shown to the members of the jury as well.
Mr. Fuentes, what did you do with these texts when you received them?
At first, I didn't do anything. I just thought it was another one of Avery's tantrums. But once I realized how severe it was and how important they were, I gave them to the proper authorities.
Let's talk about the content of those text messages. Did any of them stand out to you in particular?
If you look at Avery's fourth text message down, yes, the one starts with, well, she makes a direct threat at Coach saying, well, if he's upset about his car, then he's going to be really upset when he sees what I do to his house.
Were there any other texts that Miss Becker sent that seemed like she was telling you a plan?
Yeah, if you go to Avery's next text message down, yes, Avery sets up a plan saying, I'm going to wait until he's at work. Break in and trash it.
Thank you, Ms. Fuentes. Your Honor, I have no further questions at this time.
Does the defense wish to cross-examine this witness?
Yes, Your Honor. If I may request a moment to reposition my camera. And Your Honor, before I begin, can you see and hear me all right?
Yes, I can.
Now, good afternoon, Ms. Fuentes.
Good afternoon.
Now, from what you saw, Miss Becker never had to put a lot of effort into mock trial, did she?
That girl was never prepared, yeah.
But you always put in your best work, didn't you?
Of course I did.
And it irritated you when Miss Becker wasn't prepared, didn't it?
It stressed out the whole team, and she had a good ability, and I believed if she worked better, she had a lot of potential, but yeah, it did.
And you always had a lot of respect for Coach Brackman, didn't you?
Of course I did. I looked up to him. He was an amazing attorney.
But you never thought that Miss Becker did.
They just fought all the time, and there was just so much tension. Of course I didn't.
And when Miss Becker got a Best Attorney award, it felt like a slap in the face. Is that correct?
Well, judges like different styles, and sometimes they can't see what happens behind the scenes. So it sucked, but I just kept on working harder.
I'm sorry, is that a yes or no to my question? It felt like a slap in the face. Is that right?
Yeah.
And she had always gotten the awards that you believed others or even you deserved?
Well, she was never prepared. She didn't work hard. But, judges like different styles. So I guess, yeah.
And you claim that Miss Becker knew exactly what she was doing when she picked up that marker and vandalized the car. Is that correct?
I do. How do you mistake an Expo marker with a Sharpie? Yeah, of course I did.
And you claim that Mr. Brackman rightfully demoted Avery to the B team. Is that correct?
Previously, when she showed up late and unprepared to practice, yeah, it's part of the job of being on the A team, being prepared and on time.
And you believed that Mr. Brackman should have pressed criminal charges against Miss Becker for the car incident. Is that right?
Vandalism is illegal. So yeah, I did.
Now, earlier on, you told the jury that Miss Becker reached out to you about getting back on the mock trial team. Is that right?
She did.
And Your Honor, let the record reflect that my trial technician is pulling up Exhibit 14, which has been previously admitted into evidence.
The record shall so reflect.
Now, you claim that Miss Becker became enraged when she realized that she wasn't going to be let back on the team. Is that right?
Yeah.
And you no longer have the phone that you initially received these text messages on, correct?
Its battery was not it. It could not hold a charge, so I got a new one. Yeah.
And in fact, you sent him these screenshots 3 months after the murder occurred. Is that correct?
I sent them the next day after I had an interview with Detective Markowitz, which he previously specified the length of time that was, and he said that that wasn't 3 months.
Thank you, Mr. Hernandez. You can now take down the exhibit. And you had turned in these screenshots when you thought it was absolutely necessary. Is that correct?
Well, first I thought it was one of Avery's tantrums, and once I realized the severity, I told Detective Markowitz about it, and I gave them to him after he requested them. So yeah.
Thank you, Your Honor. No further questions.
Do the people have or wish to redirect this witness?
Yes, Your Honor. Ms. Fuentes, what is your relationship with Avery Becker?
Well, originally we were friends, but after she killed Coach, of course we're not now.
What was your opinion of her on the mock trial team?
She was my friend, but as a teammate, she was unprepared and she was late. It caused us a lot of anxiety, and it was kind of upsetting.
Why do you believe that she did not deserve the award she won?
Because she didn't work for it. I believe working hard is the way to earn anything in life.
Thank you, Ms. Fuentes. Your Honor, I have no further questions.
Does the defense wish to recross based upon that redirect?
No recross at this time, Your Honor.
May this witness be excused?
Yes, Your Honor.
Do the people have any additional witnesses that they wish to call at this time?
No, Your Honor. At this time, the people rest.
Does the defense wish to call any witnesses?
Yes, Your Honor. The defense calls Taylor Perkins to the stand. And if I may request another moment to reposition my camera.
Okay. And yes, you may call your first witness.
Good afternoon, Ms. Perkins. Please introduce yourself to the jury.
Good afternoon. My name is Taylor Perkins, and I am best friends with Avery Becker.
And how do you know Ms. Becker?
I was on the mock trial team with Avery all 4 years
Your Honor,
ago.
for the purposes of the record, we ask that Ms. Perkins please spell her last name for the record.
If you want that on the record, you're going to have to do that during cross. That is, so objection is overruled at this time. Counselor, you may proceed with your direct examination.
Yes, Your Honor. Ms. Perkins, did you get to finish your answer?
Yes, I did.
And how was your experience on the mock trial team overall?
The experience was good at some points, but it wasn't the best. If Coach Brackman didn't like you, you didn't always have a fantastic time.
And how do you think that Miss Becker did on her performance throughout her time?
Avery did incredible. Sure, she slacked off here and there, but she had raw talent. She was the best in there. She was the best we had. And despite all of her work and effort, she was demoted to our B team.
And why was that?
About a month before regionals, Avery had showed up practice the most unprepared I have ever seen her. Obviously making things up on the fly, just going with what she had. And even despite that, Brackman was furious and demoted her.
And what did you think about the demotion?
Avery was the best in there, like I've said previously, and she deserved to be on our A team. I knew she deserved to be on A team. She was the best we had.
Now, did anything important happen around the time of Mr. Brackman's murder?
Yes, the day prior, Avery had lost her phone at the mall.
And what happened that day?
Well, we had gone, Avery had come to my place after being demoted. Well, sorry, could you restate your question?
Yes, of course. And what had happened the day that Miss Becker lost her phone?
Well, we had gone over to the Fry Shack after practice, and we had gone there we were eating lunch or dinner, technically speaking, a late dinner. And at that point, we had been talking, and the mock trial team showed up and was telling Avery how sorry they were for her that she was demoted. And everyone was saying how sorry they were and said, we will find a way to get you back on the team. And at some point, Alex had joined the conversation, causing Avery to get very upset, and she had to go to the bathroom to cool down. And that must have been the last point I had seen Avery's phone with her.
And you mentioned Miss Fuentes. Did you two ever communicate in or out of mock trial?
We wouldn't talk if it wasn't necessary.
And would you say that you know Miss Fuentes?
I wouldn't say we were extremely close, but yes, I do know her.
And during the time that Alex was messing with Miss Becker's phone, would you say it'd be possible for Miss Fuentes to have stolen that phone?
I'm not aware that Alex was messing with her phone, but it is possible, seeing that Alex was distracting me by talking with me, and I was just overfueled with anger with him being insincere.
And what had happened the day after?
The day after, Avery had picked me up at my house. We had a carpooling plan, so I had tried texting her to see if she would respond. She never did. So when she showed up, I asked her, why didn't you reply? And that's when we both had realized that her phone was missing. So that's when we went up to go back where we were the other day.
And did you skip school that day?
Of course. We had nothing important to do that day, so it was completely fine.
And did you ever find the phone?
No, sadly, we did not.
And do you know of anyone who could have had some tension with Mr. Brackman?
Yes, Blair Rollins. I barely even knew her.
Objection, Your Honor, speculation pursuant to Rule 602.
Response to speculation.
Yes, Your Honor. Ms. Perkins is simply testifying based off of her perceptions and observations. And if anyone had had tension, it probably would have been a bit obvious.
Do the people have any final thoughts?
Your Honor, I don't believe that Miss Perkins having knowledge of who Miss Rollins is within her personal knowledge of something in order to testify it.
The objection is overruled. The witness may testify as to what she personally knew or observed. Counselor, you may continue.
Yes, Your Honor. And Ms. Perkins, did you get to finish your response?
No, I did not. Can you please repeat the question for me?
Yes, of course. Now, do you know of anyone who had a bit of tension with Mr. Brackman?
Yes, Blair Rollins. I barely even knew Blair, and I knew she had tension with Brackman after losing her father's murder case. Blair practically hated Brackman.
Objection, Your Honor, lack of foundation. This witness has not testified to the fact that she knew that Mr. Brackman and Blair Rollins interacted, and she did not testify that Blair Rollins told her the information that Blair Rollins hated Coach Brackman.
I believe that's appropriate grounds for cross-examination, and I will ask the jury, or I will instruct the jury to only rely on the testimony that they heard here today when they make their decision in the deliberation room. You may proceed with your direct examination.
Yes, Your Honor. And I'm sorry. Did you get to answer the entirety of your, excuse me. Did you get to answer the entirety of the question, Ms. Perkins?
No, I do not believe I did. Can you please repeat it, please?
Now, do you know of anyone who had a bit of tension with Mr. Brackman?
Wait, actually, I did finish my answer. Sorry.
Thank you, Your Honor. No further questions.
Do the people wish to cross-examine this witness?
Yes, Your Honor. Good afternoon, Ms. Perkins. My name is Feliciana Sayers. Let's start with your relationship with Coach Brackman. You thought Coach Brackman was a mediocre coach.
Yes, I did believe so. He'd never made great decisions for our team.
From what you saw, Coach Brackman thought Ms. Becker put little effort into mock trial.
Yes, that is correct.
Ms. Becker would often show up late and unprepared to practice.
Well, yes, though Avery did show up late, she still put in all the effort and still came up on top.
Ms. Perkins, my question was, Ms. Becker would often show up late and unprepared to practice, and your answer was yes.
Yes, that was correct.
To your knowledge, Coach Brackman did not like Ms. Becker, did he?
Not very much, no.
Let's talk about what happened a month before the regional tournament. Ms. Becker came to practice the most unprepared you had ever seen.
Yes, that is correct.
She was obviously making things up on the fly.
Well, yes.
And getting a bit off track from her prepared closing arguments.
Yes, but that won Avery the best closing argument and best attorney award.
Coach Brackman got so heated about her performance at that practice, he demoted her to the B team.
Yes, that is correct.
You thought Ms. Becker deserved to be on the A team.
Of course, she had 4 years to show that she deserved, and she made her place.
So you decided to quit the team in support of your best friend.
Of course, mock trial meant more to Avery than it ever did to me.
Yet you did not quit the team the day after Ms. Becker was demoted.
No, I did not.
You did not quit the team the week after Ms. Becker was demoted.
No, I did not.
You waited 3 whole weeks after Ms. Becker was demoted, a week before the regional tournament, to quit the mock trial team.
Yes, that is correct.
Leaving Coach Brackman no choice but to put Ms. Becker back on the A team.
Yes, that is correct.
Now let's talk about what happened at the practice after the regional tournament. After a heated practice, Ms. Becker sharpied Worst Attorney Award on the hood of Coach Brackman's Porsche.
Yes, that is correct, but the same night before, she told me that it was an eraser marker, or an expo marker.
Ms. Perkins, I didn't ask what Ms. Becker thought it was. I simply asked when Ms. Becker left, she sharpied Worst Attorney Award on the hood of Coach Brackman's Porsche, and your answer was yes.
Yes, that is correct.
When Coach Brackman saw this, he kicked her off the team for good.
Yes, that is correct.
In an effort to get back on the mock trial team, Avery Becker texted everyone on the team asking for help.
Yes, that is correct.
Even Alex Cifuentes.
To the best of my knowledge, she might have.
Now, let's talk about what happened on March 5th. Ms. Becker attempted to show up at mock trial practice after school.
Yes, that is correct.
She was then told to leave.
Yes, that is correct.
So she went to your house.
Yes, and we played games on our phones.
Later that evening, the two of you went to get some food at the Fry Shack.
Yes, we did.
And even later that evening, the two of you went and hung out at the mall.
We did.
The next morning, Ms. Becker picked you up for school.
Yes, Avery did pick me up that morning.
And it wasn't until you pointed it out that Ms. Becker realized her phone was missing.
No, that's not correct. We both realized at the exact same time that her phone was missing.
Ms. Perkins, I believe that was my question, that it wasn't until you pointed it out that you realized Ms. Becker's phone was missing.
Yes, that is correct.
According to you, the two of you then decided to spend the day looking for her phone.
Yes, we did.
According to you, the two of you spent the entire day looking at the mall.
Of course, we were looking for Avery's phone. I was texting and calling and whenever I
Yes,
could
Ms.
hear
Perkins.
something.
Yet, according to you, the last place you remember seeing Ms. Becker's phone was at the Fry Shack the night before.
Yes, I do remember that.
Now, Ms. Perkins, you and presumably Ms. Becker are the only people testifying today that the two of you spent the entire day together.
Yes, I'm the only one testifying.
Your Honor, I have no further questions.
Does the defense wish to redirect this witness?
No redirect at this time, Your Honor.
Does the defense have any additional witnesses that they want to call?
Yes, Your Honor. The defense calls Professor Blake Van Owen to the stand. May I proceed?
You may.
Good afternoon. Can you please state your name for the jury?
Good afternoon. My name is Professor Blake Van Owen.
As a professor, what do you teach?
I teach police practices and social justices at CU Denver.
Do you have any professional experience with police practices and social justice?
Yes, I do. I spent some time at the Aurora Police Department, and I also attained a master's in criminal justice.
Do you do anything else currently besides teach?
Yes, I spent some time as a school resource officer, and I'm also a private investigator. I've testified in court many times.
Can you please elaborate on how you've testified in court before?
Well, I've testified as an expert in police procedure, investigation tactics, the use of force, cell tower analysis, and crime scene reconstruction, and I've been recognized in several states.
Your Honor, at this time, I move to admit Professor Van Owen as an expert in general police practices, which includes the broad field of forensic evidence techniques, crime scene reconstruction, and cell tower analysis.
Do the people have any objection or voir dire for this witness?
No, Your Honor. The people have no objection to Ms. Van Owen testifying as an expert in those fields.
And Professor Van Owen has been tendered as an expert in general police practices and may testify as an expert in that area, in that field. You may proceed.
Yes, Your Honor. Ms. Van Owen, can you please briefly describe what the prosecution has claimed happened in today's case?
The prosecution claims that Avery Becker broke into Mr. Brackman's home and engaged in a brief struggle in which Mr. Brackman was stabbed.
Do you believe that this is what occurred?
No, I do not.
Why not?
Well, there are 6 points that make me think this is not true. The knife block in the kitchen, the scuff marks on the floor, how the knife was held, the text messages, the cell towers, and the lack of other suspects.
Let's go into your first issue, this knife block. Can you please describe that?
Well, we will see in a moment that the knife used to kill Mr. Brackman is a solid metal knife. And then we will also see that the knife block in the kitchen is a set of knives that are half metal and half wood. These knife sets do not match, and that means that the knife that killed Mr. Brackman did not come from this set.
Your Honor, at this time, I ask to display exhibits 5 and 8 solely for the purposes of identification.
Exhibits 5 and 8 are solely being displayed for the purposes of identification, but not to the constructive jury at this time.
Yes. Professor, do you recognize those exhibits?
Yes, I do.
And are they fair and accurate to the best of your knowledge?
They are, yes.
Your Honor, at this time, I move to admit exhibits 5 and 8 into evidence.
Do people have any objection or voir dire as to the admissibility of exhibits 5 and 8?
No objection to 5 and 8, Your Honor.
5 and 8 are admitted into evidence.
May they be published to the jury at this time?
Published to the jury.
Mr. Nolan, can you please describe these exhibits and what you've observed in them?
Well, as you see in Exhibit 5, the knife is solid metal. And as you can see in Exhibit 8, the knife set is missing one knife, but all of the knives are partially wood and partially metal. This knife obviously did not come from this knife set, which means that the intruder probably brought it into the house.
Thank you. Now, let's move on to your second problem with the case. Scuff marks, you said?
Yes. The prosecution's expert, Kyle Kuzak, identified some scuff marks at the victim's house. However, these are undateable and they do not have any real impact on whether a scuffle occurred in the kitchen or not.
What do you mean by they don't have any real impact?
Well, since we have no date on them, we cannot tell when they were made or how they were made, which means they could have possibly been made in the struggle, but they also could not have, which means they're also unreliable.
Thank you. Your Honor, at this time, I ask to display exhibits 3, 4, 19, and 21, all solely for the purposes of identification.
Those exhibits may be displayed for the purposes of identification.
Ms. Van Owen, do you recognize these exhibits?
Yes, I do.
And are they all fair and accurate to the best of your knowledge?
They are, yes.
Your Honor, at this time I move to admit exhibits 3, 4, 19, and 21 into evidence.
Do the people have any objection or voir dire as to the admissibility of exhibits 3, 4, 19, and 21?
Firstly, Your Honor, I object to the admission of 3 or 4. Both of those would be cumulative. Only one is needed to see that Mr. Brackman was stabbed.
A response, Your Honor?
Yes, let's handle just the 3, 4 package right now. So objection cumulative as to 3, I guess, and 4. I suppose dealer's choice if you want to admit only one of them.
Your Honor, these exhibits are not cumulative as they both provide different angles that provide their own information. As to the stab wound, exhibit 4, as you can see, provides information to where Mr. Brackman is on the floor, and exhibit 3 is a close-up of the wound. So they both provide relevant information.
I agree with the defense. I do not find exhibits 3 and 4 to be cumulative when offered jointly. Turning back to the people, do you have any additional objections to 3 and 4 or to exhibits 19 and 21?
Your Honor, I have no objection to 3 or 4, but may I have a moment to check exactly what exhibit 19 is, since there was no testimony of what it was?
Yes, so exhibits 3 and 4 at this time are admissible and entered into the record. You may take a moment to review exhibit 19.
Your Honor, I object to hearsay.
Does the defense have any response to hearsay as to exhibit 19?
May I consult my co-counsel?
You may.
Response. Your Honor, pursuant to Rule 703, as Ms. Van Owen has used this exhibit in the past to make conclusions about this case, the probative value in helping the jury evaluate the opinion does substantially outweigh the prejudicial effect, and Ms. Van Owen will lay foundation to the conclusions she made based on this in the future.
May I respond, Your Honor?
Okay.
Your Honor, while the opinions based on these facts and data in Exhibit 19 are admissible, that doesn't make the actual exhibit admissible.
I agree with the people, as well as following my prior ruling. The witness is, as an expert, allowed to opine about the contents of Exhibit 19. That does not render Exhibit 19 affirmatively admissible under 703. So I will sustain the hearsay objection as to Exhibit 19 and deem it inadmissible. Finally, my understanding that people have no objection to Exhibit 21. I've heard none, but this is your time.
Yes, Your Honor, I object to lack of foundation. The court has no idea what this relates to or what this is.
Does the defense have a response to lack of foundation as to Exhibit 21?
Your Honor, I'm aware that Professor Van Owen will very soon explain what Exhibit 21 means and how she is using it to state her opinions and conclusions on this case. So she will lay foundation in the future.
So let's have her lay the foundation first before we admit it into the record. Thus, at this time, Exhibits 3 and 4 have both been admitted. Exhibits 19 and 21 have not been admitted, pending further foundation being laid by the witness. Counselor, you may proceed.
Professor Van Owen, can you please describe what Exhibit 19, or excuse me, what Exhibit 21 is and how you are using it today?
Of course. Exhibit 21 is a picture of my hand holding a knife. It is used in my third problem in the prosecution's case, which has to do with how the wound was delivered and how the knife was held when the wound was delivered.
Your Honor, I believe that proper foundation has now been laid to the relevance of Exhibit 21.
Do the people have any additional argumentation that they wish to make at this time?
No, Your Honor, I have no objection to 21.
Exhibit 21 is now admitted.
Ms. Van Owen, let's start with Exhibits 3 and 4. Can you please explain the conclusions you gained based on that? Oh, actually, excuse me. Your Honor, may I publish these exhibits to the jury?
You may publish Exhibits 3, 4, and 21 to the jury.
Yes, Your Honor. Ms. Van Owen, can you please describe your conclusions based on the two pictures of Mr. Brackman and the stab wound?
Of course I can. As you can see in Exhibits 3 and 4, the wound given to Mr. Brackman lies laterally across his chest. This wound is very hard to achieve in a struggle, which is what Kyle Kuzak claims, especially given the bear hug type motion, which is also what Mr. Kuzak claims. It would have been more easily delivered from behind if the victim was sitting, which would provide the necessary amount of force to deliver the wound, as well as the same position of the knife and the wound.
So are you saying that the position of the knife in 21 correlates with the stab wound in Exhibits 3 and 4?
Yes, it does. As you can see in Exhibit 21, that type of motion would give you that same lateral wound given from behind.
And what other evidence do you have that suggests a powerful wound from behind?
Well, the fact that the victim bled out through a hole in their aorta makes me think that this wound was given from behind simply due to the power necessary to deliver that type of wound. It's very, very hard to cut through that amount of flesh and bone to reach the top of the heart and puncture it.
Thank you, Professor. Let's move on to your fourth problem for this case, the text messages. Can you please explain those?
Of course. We saw earlier in Exhibit 14 text messages from Avery Becker to Alex Fuentes, or someone named Avery Becker. These were very unreliable, seeing as, one, they're screenshots, and two, they were not downloaded using the Celebrite system.
Can you please elaborate on that Celebrite system?
Of course. The police have access to a technology called Celebrite, which allows them to download the contents of any cell phone. They used this for Mr. Brackman's phone, but they did not do this for Alex Cifuentes' phone, which makes these text messages unreliable, as they could have taken another step to ensure their authenticity.
Thank you, Professor. Your Honor, at this time, I move to display Exhibit 16, which I believe has already been admitted into evidence.
Yes, Exhibit 16 has already been admitted. You may display it to the constructive jury at this time.
Ms. Fanon, what is this exhibit?
This exhibit is a diagram of 3 cell towers that Avery Becker's phone connected to on March 6th.
Do you find it at all reliable to prove the whereabouts of Avery Becker herself on March 6th?
No, I do not.
Why not?
Well, it gives a general geographic area of where the phone may have been, but these red areas are the span of 38 square miles, which means the phone could have been anywhere within that during the times of the murder.
Can you please explain how cell towers connect to phones?
Of course, cell towers connect with phones to give the phone the best connection in order to pass through a text or a call. That means that a cell phone, whether it's close to or far away from a tower, will connect to the one with the best signal. This means that the phone could be anywhere within 7 to 8 miles of each tower at any given time.
So you're saying that even though Avery Becker's cell phone connected to the area of Mr. Brackman's house, that it doesn't actually have to be in Mr. Brackman's house?
No, it means that the phone could have been 8 miles away from Mr. Brackman's house.
And let's move on to your 6th and final problem, the lack of other suspects.
Well, I found it a little bit strange that the police didn't investigate their other main suspect, Blair Rollins.
Can you please describe what makes Blair Rollins a viable suspect in this case?
Blair Rollins is the child of a disgruntled ex-client. Mr. Brackman defended Ms. Rollins' father in court and lost the case, sending Mr. Rollins to jail. This is a very compelling motive for some child to attempt murder.
And is there any evidence that suggests Rollins did commit that murder?
Well, besides their obviously much stronger motive, they were also not at school during the day of the murder, and they seem to have vanished off the face of the planet as of today.
Thank you, Ms. Van Owen. No further questions at this time.
Do the people wish to cross-examine this witness?
Yes, Your Honor.
Proceed when ready.
Good afternoon, Ms. Van Owen. Good afternoon.
Good afternoon.
Let's talk about your opinions on the screenshots. You think they were altered or doctored in some way?
Seeing as they're photos, they can be easily doctored in a photoshopping app or even just by another phone.
In fact, you think Alex Cifuentes faked these text messages?
It's very easily possible.
That's right, possible. Nothing on the screenshots shows that they were actually doctored, does it?
They can be very convincing fakes, but again, they're not reliable because
That wasn't
they're
my
not downloaded from the phone.
That wasn't my question. Nothing on these screenshots shows that they were doctored. Sounds like your answer is yes.
I'm sorry, I appear to have cut out for a second. I couldn't hear your question clearly.
My question is that nothing on these screenshots indicates that they were actually doctored.
No.
Let's talk about the photos of the blood spatter. And you admit that the missing photos would have shed no light to who killed Mr. Brackman.
Well, I never saw the photos, so they probably wouldn't have.
Is that a yes?
I mean, I never saw them, so I'm not entirely sure.
Is it your testimony today that you're not sure that the missing photos would not have shed any light on who killed Mr. Brackman?
Well, it seems to me that they would just be routine blood splatter photos, so I'm not sure that they would have shed any light onto a suspect, but I never saw them, so I could not be sure.
Right. And you also admit that it seems to be the case where no malice should be attributed to their corruption, right?
I think I'm having a little trouble hearing you. I'm sorry, could you repeat that?
And you would also admit that no one should be blamed for the corruption of these photos, right?
No, I do not think that anybody should be at fault.
And it's not to any malice, right?
No.
All right. Let's talk about Blair Rawlins. You believe Blair Rawlins had a stronger motive?
They do have a stronger motive.
And you believe that because Mr. Brackman represented Jonathan Rawlins?
Well, comparatively, losing a parent for life and getting kicked off a team, there's a pretty big difference in anger levels there.
Question. You believe that because Mr. Brackman represented Jonathan Rawlins?
Yes.
And during the trial, or during the sentencing, Jonathan Rawlins yelled something, right?
Yes, he did.
You say that he said you say that Jonathan Rawlins said Brackman is going to die, right?
That's not necessarily true. The recording is actually part of the evidence in today's case.
Your testimony today that you do not say that he said Brackman is going to die.
I believe his statement was, "You will regret this," but I could be wrong.
Is it your testimony today that Jonathan Rawlins said, "You will regret this"?
I haven't heard the recording in over 2 months, so I could be misremembering, but I believe so.
All right, well, so it's your testimony today that you do not say Jonathan Rawlins said Brackman is going to die.
He could have said that. I don't remember clearly.
But it's your testimony okay, you prepared a statement for today's case.
I did, yes.
You signed that statement.
I did.
By signing that statement, you swore that it was complete.
I did.
It was accurate.
It was.
And by signing that statement, you swore it was truthful.
Objection, Your Honor. Improper impeachment. May be heard.
Yes, your opposing counsel actually just cut out. Okay, he's back. Yes, you can, or your objection is improper impeachment. Yes, you can be heard on improper impeachment.
My opposing counsel has not given Ms. Van Owen the chance to review her affidavit, her statement, and see if her signature is in fact there.
Defense, do you have a response?
Your Honor, that's what I'm attempting to do. I'm laying foundation that Ms. Van Owen's statement was truthful, accurate, and complete. And so any change to that statement would be improper.
Response?
I'm going to allow this to proceed. I am cognizant of the people's position on this matter, but will proceed with the impeachment as it's going, though I do understand the people's position.
So, Ms. Van Owen, that statement was, and by signing that statement, you swore it was truthful.
Yes.
So, Ms. Van Owen, in that statement, you say he said that Brackman is going to die, correct?
I do.
Right. You've heard Exhibit 22.
I believe I have, yes. It's been a while, though.
You believe you have, or you have?
I have heard it. It's been a while.
And please direct your attention to Exhibit 22. Exhibit 22 is the recording from Jonathan Rawlins' sentencing.
It is, but I cannot pull it up myself, so I'm sorry if you were trying to play it. I cannot hear it.
And Ms. Van Owen, Exhibit 22 is an accurate accurate copy of that recording.
It is, yes.
Your Honor, the people request that Exhibit 22 be admitted into evidence for its accuracy has been shown and its authenticity has been stipulated to.
Thank you. Does the defense have any Objection or voir dire as to the admissibility of Exhibit 22.
No objection, Your Honor.
Exhibit 22 is admitted into evidence.
Your Honor, permission for Ms. Sayers to play Exhibit 22.
Permission granted. Yes.
I'll get you back, Brackman, if it's the last thing I do.
Thank you, Ms. Sayers. Now, Ms. Van Owen, Mr. Rollins doesn't say Brackman is going to die, does he?
It's not verbatim, but the tone is implied.
Right. Let's talk about something you said on direct examination. You said that Blair Rollins had motive and opportunity because she was missing from school that day.
That's one of the reasons, yes.
And then, isn't it true Avery Becker was missing from school that day?
Avery Becker has an alibi in Taylor Perkins, seeing as they were both looking for the phone during that time.
That wasn't my question. I understand that you would like to explain your answer, but if Mr. Seitel would like to ask you on redirect, he may. My question was, Avery Becker was missing from school that day. Your answer is yes.
Avery Becker skipped school to look for her phone, yes.
Let's talk about the knife. You say that the knife came from outside the house.
Yes, I do.
And if that was true, it would show premeditation.
It would. It would indicate that, yes.
You've seen the Ring videos, haven't you?
I have.
You've seen the intruder in that video.
I have.
And nowhere in that video you see the intruder carrying a knife, do you?
It is not that hard to put a knife in your pocket.
That wasn't my question. You don't see the intruder carrying a knife, do you?
The intruder is not holding a knife while they enter the residence, no.
Thank you, Ms. Van Owen. Your Honor, I have no further questions at this time.
Does the defense have a redirect for this witness?
Yes, Your Honor. Ms. Van Owen, can you please describe where Avery Becker was and where Blair Rollins was on March 6th?
Well, I don't know where Blair Rollins was. They could have easily committed the murder while they were missing from school, but Avery Becker was looking for her phone.
These two are both suspects in today's case, yet one of them has an alibi. Can you please describe that alibi?
Avery Becker's alibi is, again, looking for their phone. They were with Taylor Perkins all day, texting and calling the phone.
And can you please describe the motive for Blair Rollins?
Well, Blair Rollins' father was sent to jail by Mr. Brackman. They had lost a parent that day. And comparatively, getting kicked off of a team is not that much of an angry motive to kill someone.
Thank you, Ms. Van Owen. No further questions.
Any recross?
No recross, Your Honor.
Does the defense have any additional witnesses that they wish to call?
Yes, Your Honor. The defense calls Ms. Avery Becker to the stand. Good afternoon. Could you please introduce yourself to the jury?
Yes. Hello, my name is Avery Becker.
Why are you here today, Ms. Becker?
I'm here today because I'm being accused of murdering my mock trial coach.
Did you commit this crime?
No, of course not.
We'll get more into that in a second. Could you tell the jury a little bit about your experience in the mock trial program?
Yes. Last year, I was a student at Colorado High School. Throughout my time competing for the mock trial team, I realized that it came pretty easy to me and I didn't have to try as hard as others.
And what did your coach think about this?
My coach, he hated.
Your Honor, question calls for speculation under 601, need for personal knowledge. This witness does not know what the coach thinks and cannot speculate as to his personal thoughts.
Speculation.
Yes, Your Honor. As pursuant to Rule 701, this is rationally based on the witness's perceptions and observations as she was on the team, and Coach Brackman was in fact her coach. And I anticipate that the witness will testify and give the jury a little more insight as to what led her to this conclusion. Therefore, it's not speculation.
Final thoughts from the people?
Your Honor, I stand by my position that under 602, this is speculation. Even if she was on the mock trial team with Coach Brackman, she has not laid any proper foundation for how she would know his personal thoughts, including his supposed hatred of her.
I agree with the people. I direct the witness to only testify as to what she directly observed or has personal knowledge of, but not say the contents or the thoughts of a third person. So the objection is sustained.
Ms. Becker, could you tell the jury about some of the interactions you had with Mr. Brackman?
Yes, while I was competing or performing, he always said that I was lazy because
Objection, Your Honor, hearsay. This is an out-of-court statement being offered for the truth of the matter asserted.
Response to hearsay.
Your Honor, this isn't being used for the truth of the matter asserted. The truth of the matter asserted being that Ms. Becker was in fact lazy. Rather, this is going to the effect of the listener, the effect being why Ms. Becker perceived Mr. Brackman as hating her and not liking her work ethic.
Final thoughts from the people.
The notion that Coach Brackman thought that Ms. Becker was lazy is still being offered for the truth of the matter asserted, as the defense claims that that Coach Brackman thought she was lazy, and that's why he acted in the way that he did toward her.
Objection overruled.
Ms. Becker, did you get a chance to finish your answer?
No, do you mind re-asking your question, please?
Could you enlighten the jury as to some of the interactions that took place between you and Mr. Brackman?
Well, while we were practicing or performing, he always said that I was lazy because I didn't stick to the scripts that he wrote for me because I knew exactly what I was going to ask the witness.
So how exactly would you describe your relationship between you and Mr. Brackman?
It was tense to say the least.
Now, moving on, could you tell the jury a little bit about the car incident that Ms. Fuentes mentioned earlier?
Yes. One day after regionals, we were going over what we did well and what we could work on. I thought that Brackman would maybe congratulate me on how I did at regionals and say good job on my award, but he didn't. He got on my case about not sticking to my closing.
How did that make you feel?
I was crushed. I got so mad that I stormed out of practice. When I got outside, I saw his prized possession, his Porsche. I wrote Worst Attorney Award on it, unfortunately.
Did you know that this was a permanent marker?
No, I thought I had a dry erase marker in my hand.
Now, what happened immediately after you wrote on Mr. Brackman's car?
Brackman got outside and saw what I did to his car. He was so mad. He blew up at me. And
Your Honor, again, under 602, this is speculation as to the thoughts and feelings of Coach Brackman.
I don't believe that the witnesses has begun speculating that her testimony related to what she personally observed Coach Brackman do. So the objection is overruled at this time.
Yes, Your Honor.
Ms. Becker, did you get a chance to finish your answer?
No. As I was saying, he was so mad. He got so mad and kicked me off the team.
How did you feel after you vandalized Mr. Brackman's car?
I felt awful. It was one of the worst things I've ever done in my life. I wasn't thinking of what I was doing in the heat of the moment, and it was the worst thing.
Did you ever make an attempt to get back on the team?
Yes, of course I did. The next day I went down to his office to try to talk to him, but he was not willing to talk to me, so I had to text him instead of apologize in person.
Did you ever text Alex Cifuentes about trying to get back on the team?
No, I would never.
Your Honor, may the record reflect that my trial technician is displaying Exhibit 14, which has previously been admitted into evidence.
Record shall so reflect.
Ms. Becker, did you send these texts?
No, I've never seen these in my life. I don't know who's trying to frame me, but these are not my text messages.
Thank you, Mr. Hernandez. You may take this exhibit down now. Ms. Becker, could you tell us where your phone was on March 6th of last year?
On March 6th? I really don't know. I misplaced it.
So what were you doing on March 6th?
Taylor and I realized that I lost my phone and I really wanted to try to find it. So we went to the mall and the Fry Shack to go look for it. We used Taylor's phone to call my phone and we still couldn't find it. It just kept going to voicemail.
So were you at Mr. Brackman's home on March 6th?
No, I don't know where Brackman lives.
And did you kill Mr. Brackman?
Of course not. Brackman and I never had the best of relationships, and I'm not going to try to say that we did. But I would never kill him. I'm not a killer.
Thank you, Your Honor. No further questions at this time.
People wish to cross-examine this witness.
Yes, Your Honor. Good afternoon.
Excuse me.
Good afternoon.
Good afternoon.
My name is Madeline Proctor. Let's start with the mock trial team. You thought you were the best attorney on the entire team.
I was very good at mock trial, yes.
So that's a yes. You thought you were the best attorney on the entire team.
One of them, yes.
Is it your testimony here today that you were one of the best attorneys on the entire team, or one of them, or the best attorney?
I was the best attorney, yes.
Right, but Coach Brackman did not agree with you.
No, Brackman and I never saw eye to eye.
Let's talk about Coach Brackman. You thought you were a better attorney than him, too.
I knew what I wanted to ask.
My question is simply that.
Objection, cutting off the witness.
Response, Your Honor?
No response necessary. Yeah, it's appropriate witness control. You may continue.
Ms. Becker, my question was that you thought you were a better attorney than Coach Brackman, too. Yes?
I was very good at mock trial, yes. And being an attorney for mock trial, yes.
And better than Coach Brackman?
At times it felt like it.
Is it your testimony here today that you were better than him at times, or that you were better than Coach Brackman at being an attorney?
I did feel that way, yes.
And you say Coach Brackman is the one with the ego.
He did have a very big ego.
Right. So you two would get into these arguments at almost every practice.
We would, yes.
And after one of those arguments, you were even demoted to the B team.
Unfortunately, yes.
Right, a team you call full of losers.
I thought I deserved to be on A team. I was very good.
Objection, cutting off the witness.
I don't believe that you did, though. I think that the internet is getting a little bit glitchy. You may proceed. From my perspective, you allowed the witness to fully answer your question.
Yes, Your Honor. Ms. Becker, that was a team you called a team full of losers.
Once again, I believe that I should have been on A team because I was very good.
Ms. Becker, my question was not whether or not you deserve to be on A team. It was that you call the B team a team full of losers. And your answer is yes.
I have said that, yes.
Is it your testimony today that you have said that in the past, or you are saying it now?
I have said that in the past and now, but I just believe that I should be on A team.
Okay, Ms. Becker. So understandably, you were upset that you were demoted.
Yes, I was very upset.
And you tried everything you could to get back onto the A team.
Yes, I did.
But none of that worked at first.
Unfortunately, no.
until your best friend in the entire world, Taylor Perkins, quit the team for you.
Taylor Perkins did quit the team, and I was very grateful for this.
Ms. Becker, is that a yes?
Yes, she did do that.
And just to be clear, that's the same Taylor Perkins who you claim to be with on March 6th.
I was with Taylor Perkins on March 6th. I don't claim it.
And that's the only person who you were apparently with on March 6th?
Well, we were in a public place, so I'm sure other people saw me.
Ms. Becker, you two are the only two people testifying to this jury that you were together on March 6th.
Yes, that is correct.
All right. Let's talk about something else Ms. Perkins said. I wrote it down so I wouldn't forget it. She said, we both realized at the exact same time that the phone was missing, but you realized that your phone was missing when you woke up.
I couldn't find my phone anywhere.
Ms. Becker, my question was not whether or not you could not find your phone, simply that you realized this when you woke up that morning and not in the car.
Yes, I guess so.
All right. So let's talk about another argument between you and Coach Brackman. One time, you won some awards at the regional tournament.
I'm sorry, you cut out. Can you please repeat your question?
You won some awards at the regional tournament.
Yes, Best Attorney Award and Best Closing.
But Coach Brackman said you did not deserve those awards.
He did not feel that way, but I thought so.
Right, so you got mad.
I was a little upset by this, yes.
Ms. Becker, is it your testimony here today that you were upset and not mad?
Well, upset and mad are similar, so I was mad and I was upset.
All right, so you were mad and upset. So you went outside and stormed out of practice.
Yes, I did do that.
And you saw his Porsche.
Yes, when I got outside.
The same Porsche you knew he loved.
Yes.
And you wrote Worst Attorney Award in permanent marker across the car.
I didn't know I had a permanent marker in my hand.
My question was not whether or not you thought it was a permanent marker, just that you wrote Worst Attorney Award on his car in permanent marker.
I did do that, but once again, I didn't know I had a permanent marker in my hand.
But you're the only person who can tell us what you thought that was, right?
I don't understand your question.
You're the only person that can tell us your thoughts when you vandalized his car?
Yes, because they are my thoughts.
Right. So after you vandalized the car, Coach Brackman kicked you off the team for good.
Unfortunately, yes.
Right, that made you even madder.
I was mad at the moment, yes.
Even madder?
I was very mad at that moment.
Right, so when you got home that night, you did not tell your mom the whole story.
I told her I was kicked off the team.
Becker, you did not tell her the whole story.
Unfortunately, no.
Instead, you blamed it on someone else.
I don't understand your question. Can you please clarify?
Instead, you blamed it on someone else, Coach Brackman.
Oh, yes. I did not tell my mom what exactly happened.
In fact, you told your mother that you would get back at Coach Brackman if it was the last thing you did.
In the heat of the moment, that's what I was thinking. Because
Becker, my question was not about whether or not you thought that in the heat of the moment. It was just that you said, I will get back at Coach Brackman if it's the last thing I do. And your answer is yes.
In the heat of the moment, that is what I was thinking. But I regret saying
that was not my question. My question was that you said those words, yes.
I have said that, yes.
And Ms. Becker, the more you thought about it, the more you knew exactly what you had to do, right?
No, I did not.
Your testimony here today that the more you thought about it, the more you did not know exactly what you had to do?
I misunderstood your question. Can you please repeat it?
Ms. Becker, the more you thought about it, the more you knew exactly what you had to do.
No. I knew I had to apologize.
Ms. Becker, after you couldn't apologize, you were devastated.
Devastated about what?
You were devastated because mock trial means a lot to you.
Yes, mock trial does mean a lot to me.
Thank you, Ms. Becker. Your Honor, I have no further questions.
Any redirect for this witness?
Briefly, Your Honor. Ms. Becker, how would you describe your emotional state after you vandalized Mr. Brackman's car?
Right after, I was very angry that I got kicked off the team, but the more I thought about it, I realized how much I was in the wrong, and it was a big mistake.
And did you ask Ms. Perkins to quit the mock trial team for you?
No, of course not. I loved competing with Perkins. It was fun.
Thank you, Your Honor. No further questions.
All right, the people are out of time, so there will be no recross, meaning we will proceed into closing statements. Are the people prepared to make closing statements at this time?
Yes, Your Honor. The people rest and close.
Proceed when ready.
Your Honor, counsel, members of the jury. Towers, texts, and tantrums. On Friday, March 6th, 2020, Mackenzie Brackman got an alert on his phone. Motion at your front door. Seconds later, he got another. Motion at your side gate. He rushed to the kitchen to grab a defensive weapon, but before he could get to the back door, the intruder had entered his home. He struggled with the intruder. He fought for his life, but he was stabbed in the back. And the bright light that was Mackenzie Brackman extinguished as he bled out on his entryway floor. Little did he know, his attacker was Avery Becker. My name is Chalmers Powell, and along with Madeline Proctor and Feliciana Sayers, we represent the people of the state of Colorado. In today's case, we carry the burden of proof. That means we had to prove beyond a reasonable doubt that the defendant committed second-degree burglary and, by extension, first-degree murder. As the judge instructed you, a reasonable doubt isn't a vague, speculative, imaginary doubt, but a doubt that would cause you, a reasonable person, to hesitate to act in matters of importance to yourself. We had to prove to you that the defendant entered Mr. Brackman's home with the intent to commit criminal mischief. We also had to prove to you that that Mr. Brackman died while the defendant committed that crime. That is first-degree murder. We have met our burden. Let's talk about how. At the beginning of this trial, Ms. Proctor asked you to focus on three things: towers, texts, and tantrums. Towers. The towers prove that the defendant was at Mr. Brackman's home. Her phone pinged not once, not twice, but 3 times right there. She wants you to believe that she just happened to lose her phone the day before the murder. But Taylor Perkins and Avery Becker can't get their story straight. Taylor Perkins says it wasn't until the two got together that Miss Becker realized her phone was missing. But Miss Becker says that it wasn't until the morning of March 6th that she realized her phone was missing. Either way, the claim that she didn't realize her phone was missing until the next day is not reasonable. Text. The texts prove that the defendant had the intent to commit criminal mischief. I'm going to wait until he's at work and break in and trash it. She admitted to it. She wants you to believe that someone conspired against her to frame her, but Taylor Perkins testified today that Alex Cifuentes wasn't messing around with her phone. That's the imaginary doubt. That's the speculative doubt. They just want you to imagine someone conspiring against her. Tantrums. Avery Becker got mad when Coach Brackman criticized her. So she went out, threw a tantrum, and vandalized his car. And after she was kicked off the team entirely, she was so devastated, she had all the motive in the world to go out and throw another tantrum. I'm going to get him back if it's the last thing I do. She did. And now Mr. Brackman, a beloved mock trial coach, is dead. In a moment, Mr. Winton is going to stand right here and try and sweep all of this evidence under the rug. Don't let him. towers and texts and tantrums lead to the truth. Avery Becker is guilty as charged. Thank you.
Does the defense wish to proceed with a closing statement?
Yes, Your Honor. Before I proceed, can you hear and see me all right?
Yes.
If at any time that changes, please feel free to stop me and I will attempt to fix the issue. May it please the court. You can't see the big picture when half the piece is missing. The prosecution has presented you with a half-solved puzzle and asked you to see the big picture. You cannot overlook all the missing pieces in their case. Now, I'm not here to try and sweep everything under the rug. I'm here to point out all the missing pieces in their case. Here's why these pieces are important. The prosecution had the burden of proof in today's case. They had to prove beyond a reasonable doubt that Ms. Becker committed second-degree burglary of a dwelling and first-degree murder. Let's break these charges down. The first count states that on or about March 6th, Ms. Becker unlawfully entered and remained in Mr. Brackman's home. The second count states that while Ms. Becker was in Mr. Brackman's home, Mr. Brackman died. They needed to prove both counts beyond a reasonable doubt. Reasonable doubt is such a doubt that would cause reasonable people to hesitate in matters of importance to them. A mere hesitation is all that is required for you to return the verdict of not guilty. After hearing all the pieces that are missing from the prosecution's case, you should have much more than a mere hesitation. Let's talk about some of the missing pieces in the prosecution's case, starting with their failed investigation. You heard their lead detective, Jordan Markowitz, tell you that they knew Ms. Becker had an alibi, but he chose not to investigate it. You also heard them say there was no DNA, no fingerprints, and no eyewitnesses. So what evidence do they think they have? A cell phone and a video. Let's break this evidence down. You heard Detective Markowitz tell you that Ms. Becker's phone interacted with a tower near Mr. Brackman's home. However, you also heard Professor Van Owen tell you that this tower covers an area of 38 square miles. They couldn't pinpoint a location within that massive area. As for the video, they claim that because a video showing a disguised intruder entering Mr. Brackman's home, that must have been Avery Becker. Now, let's talk about Kyle Kuzak's interpretation of the evidence. You heard them say that they lost crucial blood splatter evidence without ever letting a defense expert see this evidence. They then used this evidence to base many of their conclusions on, again, without bringing this evidence into court. Now, you also heard Professor Van Owen tell you what the evidence actually shows. Professor Van Owen explained to you that there is no reliable evidence of struggle. She also told you that because Detective Markowitz never thoroughly investigated Mr. Brackman's phone, we don't know if he had push notifications on. Today, the prosecution showed you a half-finished puzzle and asked you to overlook all the missing pieces. They asked you to do this by saying that I was trying to sweep evidence under the rug. But you cannot overlook the missing blood splatter, the lack of them investigating an alibi, and the lack of any other suspects. There's a lot of missing evidence, and you have to pay attention to it because the prosecution had the burden of proof. They had to prove beyond a reasonable doubt, and they failed. So because of that failure, you, the jury, must give the only just verdict, the verdict of not guilty. Thank you.
The people have approximately 50 seconds remaining if you wish to make a rebuttal
Your Honor,
statement.
I would object to that, as it clearly states in the rules of competition that they must reserve time for rebuttal. They did not do this in pretrial, nor did they do this before they began their closing argument.
Do the people even wish to make a rebuttal statement?
Your Honor, I do. I apologize. I totally spaced asking for rebuttal time. I apologize, Your Honor.
Does the defense want to reference the specific rule? I just want to look at the language of it.
Your Honor, if you give me just one moment, I can look at the rule itself.
I have it in front of me. It does read clearly, if properly, let's see. I see if properly reserved, parentheses, optional, and at the presiding judge's discretion. I'm going to interpret that as it's at my discretion whether it had to be affirmatively reserved or not. And in fairness, there are remaining 50 seconds, understanding that it probably should have been more affirmatively and better done. But in my discretion, I'm going to permit a rebuttal.
Thank you,
for
Your Honor.
50 seconds. Mm-hmm.
Members of the jury, Mr. Winton got up here and tried to sell you on the idea that the blood spatter photos were crucial pieces of evidence. But Professor Van Owen testified today that it wouldn't have made any difference on who killed Mr. Brackman. Mr. Kuzak testified today that the evidence shows this was a burglary gone wrong. If it was Blair Rollins, it would have been a murder gone right, not a burglary gone wrong. Find Avery Becker guilty. Thank you.
All right. Thank you, everyone. You can all, take a break, breathe a sigh of relief, go hit the head, grab a drink of water. Everyone can turn their cameras off. Presiding judges, of course, now is the time for you to complete your ballot and turn it in. While they're doing that, I'll sort of pan to give them time to score. Presiding judges, you can totally ignore me. What I'm saying will not be particularly important. And contestants, if you need to go to the restroom, get a drink of water. I'll just be introducing myself and kind of stalling for time. My name is Nicholas Monk. I am a lieutenant in the Navy JAG Corps. I'm a graduate of the University of Colorado and then commissioned into the United States Navy. I am a naval attorney. I'm speaking to you actually from Honolulu, Hawaii, where I am stationed at Joint Base Pearl Harbor Hickam. In my role as a Navy attorney, we get to do a whole lot of very fun and very interesting things. Everything from sort of basic civil work, landlord-tenant type work, wills and estates, trusts, all the way up to some pretty complicated trials and tribunals dealing with international law. We also do a whole lot of operational law about the rules of war. Earlier today, I had a session quite literally on the law of armed conflict. So would highly encourage everyone in this round to consider law school. I totally get that you're all currently high schoolers, but I want to say everyone did a really, really fantastic job. I competed in mock trial while in law school, and you were of that caliber right now. And you, of course, have a few more years to get even better. And then I've seen, you're just as good as some of the attorneys that I've seen in actual courts martials. So I think everyone here certainly has the skills to succeed in law school, to the skills to succeed as attorneys. And if you're at all interested in finding out about either the Navy JAG Corps or the other services JAG Corps, I think it's a really sweet job. I think I have a lot of fun with it. I get to go to some really cool places like Hawaii. So that'd be something that I would strongly encourage everyone to sort of put on their radar to think about. I'm happy to talk to anybody, or you can find our information online. I see that the panelist scores are confirmed. We have a handful more minutes, but I want everybody to have a good, generous break. So I would say, if each one of the panelists do want to provide a little bit of feedback, keep it 90 seconds to 2 minutes, please. So just very, very top level stuff, but I'll give you all the opportunity to come on, introduce yourselves, and give basic overall high level feedback for everyone.
Well, my name is Holly Ryan. I'm a scoring panelist. Jealous that I'm not in Hawaii. We're in Colorado and it's got a big blizzard coming in, so we're cold. I can see how both of these teams advanced to the state finals. Excellent job. I like the storytelling that started with the opening and got carried through to the questions you were asking your witnesses to the closing arguments. So a very good job. I'm rooting for you to move forward in this competition, and good luck.
I'm Jeff.
Nice job. Well within 90 seconds.
Yeah. I'm Jeff Bowen, and I'm not a practicing lawyer, although I've had a long arbitration. I've had an arbitration practice for many, many years, but I'm a professor at the University of Denver in the business school. And this is the second year that I've done this. And I would like to underscore Holly's comments. You were really a wonderful group of young people to listen to, and to have watched your knowledge of the rules of evidence, etc., was simply delightful. So I agree that I hope you all go forward.
I echo that sentiment. Hi, my name is Dalia Labrador. I'm a practicing criminal defense attorney, and I do a little bit of immigration, so this hits very close to home. I thought everybody did great. I love having here. I heard the themes, the theories, the storytelling. I thought that was very on point. I noticed that some people were having or experiencing some issues with Zoom, but it didn't really affected your performance. And I know one of your team members wasn't able to log in, and I thought you guys handled it very, very well. So congratulations. Go to law school.
And I will close out. I'm, of course, not a scoring judge, so my thoughts in some ways don't really matter, but I think everybody did a really, really good time. I'll once again reiterate what I said at the beginning. I think all of you will do fantastic in college. I think all of you, if you're interested in going to law school, will do really, really well. Would strongly encourage you to look at things like participating in mock trial in both college as well as law school. And then, think about becoming an attorney. It's a really good profession. It's got lots of opportunities to go out, do cool things, and have a lot of fun doing it. So great job, everybody. Very well done. Really pleased to have joined you from Hawaii. And thank you, of course, to all of the presiding judges for taking time out of your days. I think that's all that I have, unless the courtroom monitor has any last minute thoughts or information. But otherwise, best of luck. Enjoy your little break. Good luck both later on today, tomorrow, and in other advancement rounds.
Your Honor, we may dismiss when you are ready.